Yes.
My lord, I beg to mention item number 23, my lord. It has become infractuous. So 23,
Your good name, please.
my lord.
Your good name,
DC Chakraborty. For the petitioner, my lord.
Mr. DC Chakraborty, Learned Counsel for the petition. Who appears for the other side?
Government advocate.
Government advocate. This petition is accordingly disposed of as infectious. Yes.
May I have your lordship sign leave to mention one listed matter, my lord, item number 30, my lord. There is of the daily list, my lord. There is some urgency in this matter, my lord, because this pertains to, my lord, recovery of some excess amount which was paid to the employee, and we are suffering an interim order, and the employee is going to retire in the month of June, my lord. So if your lordship, would it be possible for your lordship to take up this matter today at any time, my lord? My other side is also here.
You have 40?
I am for the respondent number 2, 3, and 4.
3 and 4. Who's for the other side? Yeah. 2 o'clock?
Yes. Deeply. Much obliged.
May please your lordship. My lord, I beg to mention item number 19, my lord. It taken up this matter after 2 weeks, my lord.
19.
Yes, my lord.
Your good name?
G Daka.
G?
G Daka on behalf of Mr. P. K. Roy Sudhuri.
You are the petitioner in both the writ petitions.
Yes, my lord. I am the petitioner.
On request made by Mr.
G Daka.
G. Deka, Learned Counsel for the
On behalf.
petitioner. List the matter after
2 weeks, my lord.
2 weeks.
Obliged.
May I please, Lord?
So,
What should I like to mention the listing of admission matter for Monday, ma'am?
why Monday?
He is a retired person, my lord. Some MSCP benefits are yet to be cleared.
We will have it on 3rd. 3rd of May.
My lord, similar pair, my lord. Actually, it is a writ petition of 2021. Later may be listed at admission because on that,
6th May.
my lord.
May I please, your lordship. Lordship, I beg to mention for listing, lordship, admission hearing matter on Monday, lordship.
Not 8th May.
May I please, lordship? Same pair, lordship, for admission listing.
10th.
Similar, yeah, lordship, on 9 of.
10th.
Lordship, I beg to mention item number 12 of today daily list.
Item 12. Yes. What do you want?
Lordship, I'm praying for an adjournment at the conducting council. B Pathak is out of station.
Okay, on request made on behalf of Mr. B. Pathak, Learned Counsel for the petitioner.
Lordship, a date may be fixed in this matter if the matter may be taken up on 29 or 30 of this month.
Oh, that will be difficult. 7th May.
Lordship, 7th, I think there is some holiday due to election.
14th May.
Lordship, can it be on 8th May?
14th.
May I am for respondents in this meeting.
MS. CVC appears for the response.
I am paying for listing on Refixation. It was last posted on 21/6/2023.
1/6.
21/6/2023.
Yes.
After that, it was not listed.
Okay, 13th May.
Listed on 6th May.
13th of May.
May I please, your lordship? Your lordship, with the consent of the other side, I beg to mention item number 7. Your lordship, 2 weeks time may be granted to us for filing affidavit in reply.
Your good name?
F. Shaheen,
Appearing on behalf of,
Mr. R. Hussain.
on request made on behalf of Mr. R. Hussain, Learned Counsel for the petition. 2 weeks time is allowed to file reply to the counter filed by the respondents.
Okay, I am appearing for respondent on behalf of Mr. S. K. Mehdi, CCC.
Mr.
K. K. Mehdi.
K.K. Mehdi, Learned Counsel appears on behalf of S.K. Mehdi, Learned CVC. List up to 2 weeks.
My problem.
May I please, your lordship, I beg to mention for listing a writ petition. Lordship, matter is regarding salary of the petitioner. Last occasion was left over this matter, lordship. Lordship, matter may be listed on 30 April
Eight May.
of last.
Item 1 of daily list, motion.
My lord, in this matter, let notice go, my lord. Without notice, my lord, that instruction doesn't come.
Well, date of birth, my lord, was my lord, 28/12/66. But my lord, they have calculated, my lord, wrongly calculated, my lord. Thereafter, my lord, salary has been stopped, my lord, from August 2020, my lord. That is the only case, my lord. But all
But
along,
Mr. H. Das, the counsel for the petition. Issue notice. Mr. R. Darlan, the additional senior government, appears on behalf of respondents,
My lord, one,
1, 3,
three, 1, 1, 3, 5 and 6.
1, 3, 5, and 6.
My friend, Mr. Nayak is there. He's a PM.
Accountant General,
I'm a bad.
Mr. E. Bhattacharya. Learned Standing Counsel, Accountant General appears for respondent number 2. And Mr. P. Nayak, Learned Standing Counsel, Finance Department appears for respondent number 4. Notice and respondents are complete, however, extra copies. So, respondents are not the file counter. Released after 4 weeks.
date may be given, my lord, date after 4 weeks.
After 4 weeks, it will come up.
2, admission, part matter.
Lord, in this matter, your lordships heard on my part entirely. Perhaps lordships has taken noting of also. This is with regard to that compassionate family pension, continuous regular service, my lord. He was initially appointed as by following a regular recruitment process, but he was kept as, my lord, fixed pay employee. Thereafter, he was regularized, my lord. Thereafter, he died, my lord. They are not, my lord, taking into account that fixed pay service while calculating qualifying service of 1 year, my lord. The petitioner's husband, he was short of, my lord, 4 months, 12 days service from 1 year. So they, my lord, the circular says, the compassionate family pension circular says, it is to be a continuous service. So that service has to be counted, my lord. There was no break in service, my lord. I continued, the petitioner's husband continued in service. That was the background, my lord. My lord, perhaps, my lord, I have completed, and lordships has perhaps taken noting also.
Yes.
And I have given the judgments also on the
Some notings are there. Not complete noting.
lordships. Do I have to refresh, my lord, if required, my
You
lord?
can file your written argument.
Lordships.
Yes, Nayak.
Or I'll supplement in the reply. I'll file written argument. Let him make his submission and I'll supplement in the reply.
Lordship, may first see the advertisement at page 29.
You are appearing for?
I'm appearing for the BTC authority.
One minute.
Page 29.
1 minute. BTC authorities.
Yes, sir.
About the water resources department, you are appearing. And accounts and treasuries. Treasuries also you can appear,
Lord,
Nayak.
accounts and treasury, I appear, Lordship, it's under finance department.
Can you appear for both?
Lordship, my colleague A. Saliha can appear, Lord. Director of accounts and treasury, respond number 9. One aspect will remain, Lordship. Rejection to chief engineer. Chief engineer. Okay, I am appearing for the BTC authority, but ultimately it was rejected by the chief engineer of water resources department. Anyway, Lord. Case 29, Lord.
Yes.
This is the advertisement, Lordship, dated 5th of March 2008. Applications are invited from Indian citizens of male, female deserving candidates with duly filled in standard form affixed with 2 recent passport size photographs with attested copies of educational qualifications, etc. for recruitment and filling up of vacant posts lying in the Lordship will see the positions. Council, head of the department, office of district and subdivisional offices of PTC area, as per the details of post given below. So as per this advertisement, although it is not mentioned whether the post are some sanctioned vacant post or fixed pay post or any other post, it's merely mentioned as vacant post lying in the council. Council means it is the secretariat, head of the department, directorate, and office of the district and subdivisional assistant. Next, your lordship will get the post of junior assistant. Next, I am coming to the next page, lordship 30. Age. The candidates who are already engaged to the office of the CHD, its council head of the department, lordship. Council head of the department is the director. District subdivisional office on fixed pay. The BTC, either grade 3 or grade 4, also need to apply. So those who are already working as fixed pay employee, they were also asked to apply. Next pay, next lordship, candidates, applicants who are BTC secretariat. BTC secretariat means council, lordship. Council and secretariat synonym. Office on fixed pay basis, either on grade 3 and grade 4, may also apply as there is no sanction post in BTC secretariat office of the at present. So it is not mentioned in the advertisement whether the vacant post is a substantive vacancy or fixed pay vacancy or work hours vacancy or casual vacancy. It is not mentioned. Secondly, it has been in the advertisement itself, it has stated that those who are already in the fixed pay, they also need to apply. At page 39, lordship. This is the order passed by the Office of the Joint Commissioner Transport. Pursuant to that advertisement, a selection was conducted, interviews were taken. And thereafter, lordship, on 28 February 2011, advertisement of 2008, this is an order of 2011. In pursuance to the letter number BTC E221 so and so etc. 19 to 2011 from the Undersecretary Personnel Department BTC Koprasar and letter number so and so dated 25 to 2011 from the Joint Secretary Transport Department BTC Koprasar. The following persons are hereby appointed as a junior assistant LDA on fixed pay at the rate of 5,200 rupees 5,000. Both are different. Only per month with effect from the date of their joining. The appointment person shall be submit medical fitness certificate from the Joint Director Health Services of the district concerned. The appointees shall join in the place of posting immediately. At serial number 28, lordship, page 42, one Manik Chandra Roy is there. He is the husband of the present petitioner, lordship. In the office of the, but one thing your lordship will notice, in this order, lordship, nowhere it has been mentioned that this order has any connection with the advertisement issued in the year 2008.
Yes.
So if, unless my friend places some document, lordship, that no, this.
No. Where's this letter of 19 to 2011 and 25 to 2011?
Yes,
This-
that
this would-
letters are, in
This
fact,
would have a
in fact,
bearing on the matter.
in fact, I asked the authority to place these documents, Lordship.
Uh,
They are unable to trace out any such document.
How can it be?
So it is their Lordship. Even the appointment letter,
See,
Lordship.
one letter is written from the Under Secretary Personnel Department,
Yes.
BTC.
Mm.
And one letter is written by the Joint Secretary Transport Department, BTC.
Yes.
Obviously, they should have this letter.
Even the appointment letter at page 43, Lordship. Pursuant to this order, one appointment letter was issued at page 43.
No.
And my authorities are saying this order is not at all traceable in the office of the Transport Department.
How can it be?
So it is the fact, Lord.
No, but then this letter of, this order of February 2011,
Lordship.
it reflects two letters.
Yes,
Now, these two letters would have a bearing in the matter.
yes,
This would maybe
Lordship.
or may not, but it may it may say that in view of the advertisement that is so and so,
Yes. Some mention should. have
some
been there.
mention should be there.
Lordship, to clarify that point only, I asked the authority, please furnish me these two letters to show whether this order has any connection with the advertisement issued in the year 2008 or not.
Hmm.
But these letters are not traceable. And this, they also took the stand that even the appointment order at Annexure 6, page 43 is also not available in the department document. But I'm only to the extent I'm saying that these are not traceable. I'm not denying or disputing these letters, Lordship. Okay, at this stage. But one stand will remain that this order of 28 February 2011, it prima facie it shows it has no connection with the order.
No, that's the reason why I'm asking you. You're making a submission that this order has no connection with the advertisement.
It shows, Lordship. Reading
According
of this
to the order.
Yes.
Then you'll have to produce these two letters. Then only we
Your
can go with
Lordship,
it.
your Lordship directs and Lordship. I have already inquired for these two letters. But that is the reply I received, Lord.
Do you have a copy?
No, Milord, subject to Milord, what my friend, Milord, this submission made by my learned friend, Milord, it's not based on record. There is no stand in the affidavit disputing this order or the appointment order.
No, he is not disputing this
No,
order.
he is disputing. He is
No,
saying
I'm
that
not
this,
disputing. I'm
why
only
I'm saying so,
only saying
he's creating doubt with regard to this letter,
No.
that connection,
He is not disputing this order or the order of appointment.
my lord.
But he's saying that this has no connection with the advertisement.
That saying has to be based on record, my lord,
Yes.
has to be there in the affidavit. It's not there in the affidavit.
Yes, proceed.
How can this submission be made, my lord?
no. As already I have submitted, I'm not denying. But prima facie reading of this order, nothing will transpire that this has any connection with the
Okay.
advertisement of 2008.
Yes.
Then at page 44, Lordship, this is the actual appointment order. It is issued by the Joint Commissioner. This is pursuant to this order of 28 February 2011. Type copy is at page 43. Lordship, in pursuant to page 43, in pursuance to the letter number so and so dated 9 to 2011, 19 to 2011 from the Under Secretary Personnel Department BTC Koprajar and letter number BT Transport so and so 25 to 2011 from the Joint Secretary Transport Department BTC Koprajar. The following persons are hereby appointed as junior assistant on fixed pay at the rate of rupees 5,200 within bracket, Lordship will see rupees 5,000. It's a government order, Lordship. See the contradiction, 5,200. In writing, it says 5,000. Only per month, with effect from the day of his joining duty. The appointed person shall submit medical fitness certificate from Joint Director, Health Services, etc., etc. Now, from reading of this order, Lordship, three things transpires. One, the post against which the petitioner was appointed was junior assistant. Second, Lordship, it was on fixed pay. And third, Lordship, his salary was fixed at rupees 5,200 or rupees 5,000, whatever is correct, Lordship.
No, this is the same letter, annexure P5 and annexure P6.
Yes.
It's the same letter.
No, this is pursuant to the earlier order at page 39. The main order is at page 39. Subsequent is the specific appointment letter in respect of the petitioner's husband. Down below, Lordship will see the name Manik Chandra Roy.
Okay.
So
So on the same day, another order was issued.
issued. Lordship will surprised to know on the same day he joined the post. One order issued on 28 February. The second order was issued on 28 February. And that on the same day, 28 February, he joined service at 10 a.m. Page 45. Page 45. Sir, with the reference to the letter quoted above, I have the honor to inform you that I have joined in my duties as grade 3 LDS staff on morning 10 a.m. of 28 February 2011. I'm not saying that these letters are fake documents or these orders are fake. But I'm only saying that these letters are not available in the department. And why it may not be available in the department, Lordship? The one reason may be this, Lord. One day, 3 orders were issued, 2 orders were issued. Same day at 10 a.m. he joined service. Order was issued at 9 then. At 9 a.m. order was issued, he joined at 10 a.m. I'm not disputing. Next page, your Lordship will see page 46. Page 46, this is the approval of appointment in grade 3 post. Your letter number here, 2 letters are mentioned, Lordship. I'm producing these 2 letters. With reference to the subject cited above, I am directed to state that Boroland Territorial Council is pleased to approve the appointment of following 7 numbers of fixed pay employees of entrusted Department of BTC in the vacant sanction post. Now, Lordship will see the word. Vacant sanction post. As indicated below, under the Water Resources Department in Kokrajhar, Baska District, BTC, as per decision of Executive Council meeting of BTC held on 4th September 2017. The second column, your Lordship will see first column, serial number, second column, name of the fixed pay employees. Third, Lordship, existing department. Fourth is the place of posting, new place of posting. Lordship will see at next page, Lordship, serial number 1, Manik Chandra Roy.
Serial number.
Next page, Lordship, page 47. This is junior assistant, section assistant. Serial number 1, Manik Chandra Roy. Earlier, he was working as junior assistant under the establishment of Joint Commissioner Transport Department. Now he has been posted in a vacant sanction post of section assistant in the office of the Executive Engineer, Baksa Water Resource Department Division, Mushalpur. You are therefore requested to take necessary action for appointment and submit copy of declaration of willingness duly signed by the employees concerned along with their joining report with 7 days from the date of joining in duty. Subsequent page, Lordship will see page 48. This is his appointment in the sanctioned vacant post, Lord. In pursuance of the additional Principal Secretary, Boroland Territorial Council, Kokrajhar's memo number so-and-so, and additional Chief Engineer, Kokrajhar Zone Water Resource Department, BTC, Kokrajhar, letter number so-and-so, dated 24/7/2018, for filling up the post subject to discharge without notice and without assigning any reason thereof, and subject to satisfactory police verification report, the following fixed pay employees are hereby appointed as section assistant against the vacant post in the pay structure. Pay scale is also mentioned, plus other allowances as admissible under the government rules from the date of joining under the establishment of Baksa Water Resource Department. Lordship will see his name at serial number 1. Subsequently, Lordship will see his service will be covered by the new pension scheme. Next paragraph.
Yes.
Page 52, Lordship. This is the death certificate. The incumbent died on 7/12/2018. So he joined in service on 26/7/2018 and he died on 7/12/2018. Then Lordship may please come to page 59. Page 59, Annexure P16. This is an application by the petitioner herein to the additional chief engineer, Kokrajhar Zone Water Resources. Lordship may kindly see the content. With reference to the subject above, I would like to state that my husband, late Manik Chandra Roy, was appointed as section assistant by appointment letter number so and so dated 26/7/2018 in the office of the executive engineer Baksa, Water Resources Division, Mosalpur, and he was posted at Udalguri Water Resources Subdivision at Udalguri district. But sir, unfortunately, he died on 7/12/2018. As such, I am in great distress. So I would honestly request you to kindly grant me all the compassionate compensation benefit as per government rule of my husband. So Lordship will see the claim of the petitioner in this application. He claims compensation benefit in respect of her husband, who was appointed in service, Lordship, on 26/7/2018. But there is no mention about the earlier fixed pay service. She has no grievance. Even the petitioner husband, Lordship, was appointed in the year 2011 till his death, Lordship, never raised any objection, or he was never aggrieved that please appoint me against a regular sanction post. My selection was against a regular sanction post. That was not his stand. Even in this application, the petitioner's stand is that my husband was appointed on 26/7/2018. So she is claiming benefit in respect of her husband's service, who was appointed on 26/2018. Page 61, Lordship. This is the second application. Now the tone has changed, because now she has got some expert opinion. Lord.
No. Yes.
Principal Secretary, Borland Territorial Council, Kokrajhar, with dispute respect. Lordship may kindly see the second paragraph. My husband, late Manik Chandra Roy, ex-section assistant, had been working previously in fixed pay, 5,000 at the rate of rupees 5,200 PM as junior assistant in the office of the Joint Commissioner of Transport, BTC, Kokrajhar, regularly since 28 February 2011 by order number so and so dated 28/2/2011. Next paragraph. That sir, subsequently, my husband, Len Manik Chandra Raja, ex-section assistant service was regularized by the BTC authority and the executive engineer Baska Water Resources Division, Musalpur, by the office and order number so and so dated 26/7/2018. And he joined in his service in the office of the executive engineer Baksa Water Resources Division, Musalpur, on 26/7/2018 as section assistant till his date. That's sir, unfortunately, my husband late Manik Chandra, ex-serviceman, ex-section assistant, died on 7/12/2018 in service. Death certificate, etc. By left behind his wife and two minor daughters, along with old his father and mother. That's why I prayed an application for awarding me compassionate benefit and others to the additional chief engineer, Kokrajhar Zone, CHD, Water Resources Department, BTC Kokrajhar on 21/2/2019. This is the earlier representation. Along with next of kin disease issued by the subdivisional officer, Parpotjara Kokrajhar by letter number so and so. And also personally visited in the office of the executive engineer Baksa, Water Resources Division, Musalpur for early release of the GIS of my deceased husband as per rule. However, the action taken from the authority concerned is not known to me till date. That further, on 13/8/2019, another prayer petition was submitted in the office of the Additional Chief Engineer Kokrajhar Zone CHD, Water Resources Department BTC, Kokrajhar, taking necessary action for release of my legitimate claim, and the authority concerted forwarded the application to the executive engineer Bhaskar Water Resources Division Musalpur by memo number so and so, that is 8/8/2019, but action taken in this regard not known to me till date. That's it. It is also not possible for me to visit frequently to the office of the executive engineer Bhaskar Water Resources Division Musalpur by residing at Rupsi along with next paragraph. I'm coming to the next last but second paragraph, that the authority concerned is completely violating the government rules order for keeping aloof in my case and not setting the claim for at least 1 year. For last 1 year, the reason is best known to them. Therefore, in the above circumstances, I fervently pray for your honor to have kind enough to arrange for issue of necessary direction to the authority concerned to take immediate action in my case for release of legitimate claim as per government rules at the earliest, and for which act the kindness I shall ever pray. Next page, your lordship will see this is an order by which the GIS subscription amount was released to the petitioner. Lordship may kindly see the second paragraph, page 63. His GIS subscription amount was paid with effect from 26/7/2018 to 7/12/2018. Lordship, this is the date of appointment against the sanctioned vacant post, and next one is the date on which the petitioner's husband died. So GIS subscription was only between this period, and that amount has been released to her. Petitioners has no objection to this. Next page, your lordship will see. This is the unutilized earned leave salary. Last line, your lordship see, who expired anyone after rendering service with effect from 26/7/2018 to 7/12/2018. So her leave encashment benefit was released for the period 26/7/2018 to 7/12/2018. Petitioners accepted that without any objection. Because the petitioner was fully aware. Petitioners means her husband, and the petitioner herself was fully aware that his service prior to 2018 was not a regular service. Lordship may kindly see the prayer. Serial prayer number 3. Pair number 2 and pair number 3. Issue read in the nature of mandamus directing the respondents to release the regular pay of petitioner's late husband in pay band 14,000 to 4,900 plus grade pay of 5,600 per month with effect from 28/2011 to 25/7/2018. Now, if it is a regular appointment, as claimed by the petitioner authority, then the petitioner's husband should have raised some objection. He was the employee. Petitioner's wife is not the employee, Lordship. She cannot be the aggrieved person. Aggrieved person should have been the husband. He being the service employee, Lordship. He never raised any objection. Now the petitioner's wife is claiming regular salary in respect of the period, Lordship, in which she was appointed against a fixed pay. Next pay, same regular pay scale. So they are basically claiming regularize my earlier part of service. On one hand, she is claiming that entire period you should count as regular service. On the other hand, she is claiming that please regularize my earlier part of service. Lordship, may come to page 54.
Page
54.
yes.
Annexure P14. Lordship, this is the notification dated 14 September 2017. This is a scheme for compassionate family pension in lieu of compassionate appointment, in short called as compassionate family pension. I'm only reading the relevant portion, Lordship, serial number 4.
Yes.
Serial number 4. In view of above, it has been envisaged to replace the existing policy of appointment on compassionate ground of the dependents of state government employees who die in harness by scheme of compassionate family pension in lieu of compassionate appointment, in short, called as compassionate family pension CPF scheme. So the earlier scheme of compassionate appointment has been replaced by this notification of compassionate family pension for the state government employees. 5.1 Lordship will see, next paragraph, 5.1. The applicable definition of family of the employee dies in harness will be the definition of family that is given in Assam Services Pension Rule 1969. Next page, your Lordship will come to page 55, 5.3. 5.3. I am only reading the however portion. However, the government servant, Lordship will see the phrasing, government servant must complete minimum 1 year of continuous service without break before date while in service. So he has to continue 1 year of service as a government servant. Government servants means working against a substantive vacant post. Next, Lordship, 5.9. This will be applicable to all employees of state government, provincialized employees, and all others as eligible under State Assam Services Pension Rule 1969 of all state government employees under NPS category and all India services officers born in Assam cadre. So first two line important. This will be applicable to all employees of state government, provincial employees, and all other as eligible under Assam Services Pension Rule 1969. Eligibility to pension laws, 1969 rules, that is Rule 31.
So what you're trying to say is that since the petitioner's husband was appointed only on 26/7/2018 to a sanctioned post, and he died on 7/12/2018, he did not complete 1 year.
Yes. The 1 year as per the requirement of this notification has not been completed by the husband of the petitioner. That is why she is not entitled to compassionate family pension. Now, Lordship, please come to my affidavit, Lord. Oh, 82.
Which affidavit?
Lordship, this is an affidavit filed by Kishore Kumar Pathak. Executive Engineer, Water Resource Department, BTC Lodge. It was filed on 28/3/2023.
Yes.
Lordship, I am coming to paragraph 15.
Yes.
That page 86 now.
Yes.
That as regards to the statement made in paragraph 22 of the writ petition, the deponent begs to state that late Manik Chandra Ray, who expired on 7/12/2018, after rendering service with effect from 26/7/2018 to 7/12/2018, that is 4 months, 12 days. He was appointed a section assistant by TO memo number so-and-so dated 26/7/2018, and the additional chief engineer Kokrajhar Zone Water Resource Department, BTC Kokrajhar, by letter number so-and-so dated 24/7/2018, after due approval by the additional principal secretary BTC Kokrajhar's memo number so-and-so dated 6/7/2018. Let Manik Chandra Ray, who also served in fixed pay at the rate of ₹5,200 as junior assistant in the office of the Joint Commissioner of Transport BTC Kokrajhar since 28/2/2011 to 25/7/2018 by the order number so-and-so dated 28/2/2011. Fixed pay is not pensionable service as per government rules. There is no provision for compassionate family pension scheme for those who expired before completion of 1 year government service by clause 5.3 of the government notification number so-and-so dated 14/9/2017, wherein the circular states that the government servant must complete minimum 1 year of continuous service without break before date while in service. So the matter was communicated to the Principal Secretary BTC Kokrajhar, seeking advice as to whether benefits may be allowed or not to Mrs. Beckman. Paragraph 16, Lordship. As regards to the statements made in paragraph 23 of the writ petition, the deponent begs to state that the authority advised that the petitioner Srimati Manjula Ray Adhikari, wife of late Manik Chandra Ray, does not come under the compassionate family pension scheme, as late Manik Chandra Ray ex-action assistant has not completed 1 year of complete service period. An employee must have completed minimum 1 year of service for compassionate family pension scheme. The CPF is paid with the recommendation of the state government. Be it stated that she was advised by the undersigned to communicate the matter to the Chief Engineer Water Resources Department for taking necessary action by this letter number 4/11/2020. So that is the basically stand taken by the government lordship. So as the husband of the petitioner completed only 4 months, about 5 months service lordship as a regular, against a regular back and forth, his service would not qualify for compassionate family pension to the petitioner lordship.
So according to your affidavit, you are not denying that he was serving from 28 to 2011.
Lordship.
As per your affidavit, he has been serving with effect from 28 to 2011 on fixed pay.
First part on fixed pay, but he joined, he was appointed against a substantive vacancy only in the year 2018, July 2018.
So you're not denying that he was serving as a fixed pay.
Yes, that is not denied.
You are
That
not-
is why I
that's
thought,
in your
I mean,
affidavit.
though those documents are not available in the department, it could not be traced out. I'm not denying. So his late lordship, what is that? Use of denying the fact. Now, lordship, only 2 questions will arise. If lordship comes to the pension rule, lordship. Lot, 138.
Page?
Book will be different, lordship. It will The rule will be 138 to 142.
138.
Lordship. Family pension scheme.
Family pension rules.
Yes. Family pension scheme. It's a Assam Services Pension Rule 1969. I'm taking up rule 138 to 142.
So yes.
Lordship will find at page 140, rule 140. Except as otherwise provided in rule 42, a family pension not exceeding the rate mentioned in rule 141 will be admissible in case of death of an officer while in service or after retirement on or after 1st January 1964, if at the time of death, the retired officer was in receipt of compensation, invalid retiring superannuation. This line is important. In case of death while in service, the government servants should have completed a minimum period of 1 year of service. So this 1 year period is Lordship, it's a statutory provision.
What is the definition of government servant? Is it given here in the pension rules?
Government servant Lordship will see a rule 31.
Rule
31. Conditions of qualifying service. Lordship will see the second condition. The employee must be substantive and permanent. These are the three conditions. Second one is important. Now, if your Lordship comes to rule 67,
rule
67.
yes.
Lordship, it is a condition for relaxation. Upon such conditions as he may think fit in each case to impose, the governor may condone a deficiency not exceeding 12 months in the qualifying service of an officer. But Lordship will come to note 4. In the case of officers mentioned in Rule 17 of minimum qualifying service required for eligibility to death-cum retirement gratuity under Section 2 and family pension under Section 3 of Chapter 8 is 5 years and 20 years respectively. In case where the qualifying service is less than the prescribed minimum, the deficiencies shall not be condoned by invoking the provisions of this rule. Similarly, the deficiencies should not be condoned by invoking the powers under this rule, where the service of an officer mentioned in Rule 18 falls short of prescribed minimum 5 years for death-cum retirement gratuity or 1 year for family pension under Section 4 of Chapter 18. So, though in case of the employee or in case of normal pension, up to a period of 12 months can be condoned by the governor. In case of family pension, this 1 year period cannot be condoned.
Yes.
In the native. What when you have a deadline? Lordship, 3 judgment I'm relying upon Lordship. First one is 2011 3 SCC 436 that I have not furnished out.
Where's the copy?
The copy lot, it's a small paragraph lot. If it, I have not got the second copy. It's a small paragraph. Very small.
2011,
It's 2011 3 SCC 436. It's date of Urissa and another versus Mamta Mohanty. Lordship, I'm relying upon paragraph 36.
yes.
Very small, 2 lines, Lordship. Therefore, it is a settled legal proposition that no person can be appointed even on a temporary or ad hoc basis without inviting application from all eligible candidates. That is my first submission, Lordship. Just because one advertisement was issued, it is not necessary to conclude that the post has to be a regular sanction post. Even for appointment against ad hoc
Let
post,
us see that just. Can you give us?
Lord, I'm giving the book itself.
Can you get it? Six.
36.
See, here it says no person can be appointed on temporary or ad hoc basis without inviting applications from all eligible candidates.
That is what I'm implying, Lord.
But here there was an advertisement.
Yes, I'm saying just because an advertisement is issued, it doesn't imply that the post that has been advertised has to be a sanctioned vacant post. This judgment says without advertisement, you cannot appoint against even a ad hoc post or casual post.
So that is a different thing.
That is what
Without even for an ad hoc appointment,
advertisement is necessary.
advertisement here also.
So advertisement we have issued.
Advertisement is there.
So that is why I'm saying just because the advertisement is necessary
Hmm.
as per this law.
So, here it speaks only about advertisement.
Yes, advertisement means selection law.
So advertisement was the,
Hmm.
he appeared in the
Yes.
selection process.
Yeah.
He was successful.
No, it is the submission of the petitioner. One advertisement was issued, one selection process was conducted. According to him, it's a regular selection. I'm not objecting. But it doesn't mean just because in the advertisement, nowhere it is mentioned that it is against a sanctioned vacant post. Post is not mentioned, scale is not mentioned. It only says it's vacancy. So just because the advertisement has been issued, it doesn't mean that it is an advertisement for appointment against a regular sanction post. Because otherwise also it is necessary for me to issue an advertisement.
So that's fine, that's fine. What you are saying is correct. But then this particular ruling is not applicable in this case because here it talks about only advertisement for ad hoc, even for ad hoc. Here there was an advertisement. We're not going into whether the advertisement was against for sanctioned posts or non-sanctioned posts. All right, but at least there was an advertisement.
Yes.
So here there was an advertisement.
No, not in that this judgment makes it necessary for the government to make appointment even against the ad hoc post or casual post only by publishing an advertisement.
That is what I'm saying. That is what you're saying is correct. According to you, even for an ad hoc appointment,
Advertisement is necessary.
advertisement is necessary.
In this
case also, there was an advertisement.
advertisement has been issued.
Yes.
Now my friend is saying just because an advertisement is issued, it has to be implied
That is a different aspect.
That
That
is
this court will consider.
only to contradict that just because an advertisement is there, it doesn't imply that the post has to be a regular sanction post. That is what I'm submitting, Lord.
That part is.
Second judgment, Lordship, I'm relying upon 2008-15 SCC 380.
Yes.
This paragraph 38 and 39. This is State of Haryana and others versus Sakuntala Devi. Paragraph 38 and 39.
Yes.
2008-15 SCC 380.
2008-15 SCC.
380. Paragraph 38 and 39. Wait, yeah. The scheme in terms of para 3 is applicable to all regular employees in pensionable establishment, temporary or permanent, who are in service. Thus, whether temporary or permanent, the employee must be a regular employee, which would mean an employee appointed on a regular basis, that is in accordance with rules, only because service of an ad hoc employee were continued. The same would not mean that thereby their status has been changed. It will bear repetition to state that that status of an employee can change either by reason of a contract or by reason of a statute. Nothing has been shown to us that employee concerned either under the contracts of service or under any statute or statutory rules became regular employee of the state. If the scheme did not apply to the respondents, the provisions as to how the scheme would be administered are not of any significance. 39. The contention that the family of an employee would be entitled to the benefit of family pension in the case of death of a government employee, if he had completed a minimum period of 1 year's continuous service without break, cannot be accepted. As stated herein above, an employee must be a government employee at the first instance. He must be working in a pensionable scheme. He only in that capacity should have completed a minimum period of 1 year of continuous service without break, which would mean that he must be a temporary or permanent employee. So that is my exact submission note. You have to complete that period of 1 year only as a government servant, not as a fixed pay employee or any other status. Second judgment, Lordship, I am relying upon 2022 SCC Online SC 818. State of Nagaland versus Nisbi Asumi. I'm relying upon paragraph 4 and paragraph 8. Paragraph 4, Lordship. Learned counsel appearing on behalf of the state has vehemently submitted that the impugned judgment and order passed by the High Court directing the appellant state to regularize the service of the deceased employee 1 day prior to his demise is absolutely unsustainable. She has made the following submission. 1, that during his lifetime, the deceased employee never claimed regularization. And 2, that the respondent, original petitioner's widow, claimed regularization after a period of 12 years from the date of the deceased employee. I am in the first one, Lordship. During his lifetime, the deceased employee never claimed regularization. Paragraph 8. It is required to be noted that the deceased employee died in the year 2005. During his lifetime, he never claimed any regularization. That the respondent herein, original writ petitioner, wife of the deceased employee, claimed the regularization after a period of 12 years. I am not on that. From the date of the deceased employee. At the time of date, the deceased employee, he was not entitled to regularization as he was much below in the list of the work search employee whose services were to be regularized. Under the regularization policy of services of the work search employee were required to be regularized as per the seniority and as and when the vacancy arises. The services of the work search employees, even who were senior to the deceased employees, were regularized in the year 2009, that is after the date of the deceased employee. Despite the above, the High Court was directed to state to regularize the services of the deceased employee 1 day prior to his death, which otherwise his service were not required to be regularized as his turn had not come and he was much below the seniority list. I'm not relying upon the entire paragraph. I'm only to the first paragraph, Lordship. The deceased employee was never agreed with the decision of the government to appoint him against a fixed pay post, Lordship. Secondly, Lordship, here, Lordship, the petitioner is claiming regularization of the fixed pay period, Lordship. My submission will be, Lordship, by following the judgment, paragraph 53 of the Umadevi judgment, Lordship. His appointment was only in the year 2011. And as per the Umadevi judgment, only 3 conditions are there. Only if those 3 conditions are fulfilled, the consideration of regularization of a particular employee comes. Lordship, in this case, Lordship, as per Umadevi judgment, Lordship, such an appointment has to be prior to 10 years prior to date of Umadevi's judgment. That is, his appointment has to be prior to 1996. Only then his case for regularization can be considered. It is an engagement only of the year 2011. So in my humble submission, Lordship, that regularization period should not sustain, Lordship. That period cannot be regularized. But these are my submissions, Lordship. These are my citations I am relying upon. In that view of the matter, Lordship, what I am submitting, Lordship will dismiss this petition as his regular government service, Lordship, only 4 years, 4 months, and few days, Lordship. It's not completed or complete 1 year as required by the notification and by the statute law.
One minute. What you are saying is that the order of 28 to 2011
Lordship.
has no connection with the advertised. Correct.
Lordship, that is doubtful, Lordship. What I am saying, this order,
So, no. This
nothing,
is what is lingering in my mind.
Lordship.
I want to be very clear on this point.
even I am not sure, Lordship, because nothing transpires from that
So
order.
where are these 2 letters which is reflected in the order dated 28 to 2011?
Lordship, I have letters, Lordship, I have specifically written to the authority. That please furnish me those 2 letters. I also want to see whether this order has any connection with the advertisement published in the year 2008 or not, whether if there is any connection. Lordship, what they orally inform me, Lordship, they are still unable to trace out those copies. Even the appointment order, initial appointment order, is not available in the department. I don't know what is the exact correct, Lordship, but at this stage, Lordship, I don't want to dispute also, Lordship, because.
No, disputing is a different thing. What is disturbing this court? Is because of your statement that the order of 28 to 2011 does not speak about the advertisement.
Yes.
Correct?
Yes.
But it speaks a few letters written by one under secretary or one joint secretary
Of the department.
of the department. Can you make an attempt?
Lordship, if Lordship directs, Lordship, definitely I can write another letter to them.
We'll conclude the hearing today. Just let us see if you can.
In that case, Lordship will grant me 2 weeks' time, Lordship, I'll make another attempt with the authority. Let's see, Lordship, if they can this time find out. With my learned phrase, I have some available documents to clarify that aspect, Lordship.
এটা dispute কৰা নাই দুইটো বস্তু no way affidavit টো নাই impugn order টো নাই আপোনালোকৰ order টো ক'তো নাই for the first time this has been raised.
Otherwise also that is in my humble submission, Lordship. Basically, the issue is whether the conditions of that notification are fulfilled or not.
Yeah, that's
And
one-
in my
that's-
submission,
that's one
Lordship,
part,
it doesn't
one
fulfill.
part. Yeah, even if it is not stated in the affidavit. Now, this court wants to clarify one point. That those two letters. Let us make an attempt once. If it is not available, then there's a different thing. Let us make an attempt once.
Lord, Lordships want to have a satisfaction, my lord. I am not, my lord, interfering with that satisfaction process, my lord. Lordship will have that satisfaction because it's required, my lord. But so far as this period is concerned, my lord, fixed pay service period is concerned, that is, in the affidavit, my lord, this was never disputed. That, he served as in that, fixed pay period, my lord. In fact, there is a communication by executive engineer, Baksa Water Resource Division. My lord, my friend has not referred to that letter. Therein also they say, on the last occasion I referred to this letter, my lord. Therein also they say that the husband of the petitioner served for that period. Now issue,
That he served in the as fixed pay. That is
I'm
not
coming,
disputed.
I'm coming to that, my lord. Now issue is, the circular doesn't say anything about sanction vacant post. It say 1 year of continuous service a person has to be
Government servant.
government servant. So it say, if I may read again, my lord, it say 1 year continuous. I'm in a, because lordship will kindly appreciate one thing, this is not a case before your lordships that a fixed pay employee has come up before your lordships or a ad hoc person is before your lordships, that that this honorable court will regularize my service and give the family pension. He has already been regularized. What the petitioners is praying is that, my lord, that earlier service, that has to be accounted for qualifying service. My friend also referred to judgments. The petitioner's husband, he was a government servant. There is no dispute. And being a government servant, the period has to be, my lord, it says the circular, I'm just taking a lordships again. It says only 1 year continuous service. It doesn't
No,
say.
1 year continuous service as a government servant. As a government servant.
Yes, he was a government servant.
Just
So
one
this,
interruption, Lordship. 5.9, it has a specific reference to whom this applies, Lordship. This will be applicable to all employees of state government. Page 55. Page 55. 5.9. This will be applicable to all employees of state government, provincialized employees, and all other eligible under Assam Services Pension Rule 1969. So employees in whose case this pension rule of 1969 applies, this notification will apply only in those cases. It doesn't apply, this rule do not apply in case of fixed pay employees.
that 2008 judgment. of the Supreme Court.
2008.
Whether you're furnishing a copy.
Lordship.
Para 38 and 39.
On this particular point, Lordship, there are several judgments are there. I have produced only one, Lord. Several judgments are there.
Says he must be working in a pensionable scheme.
My lord, the facts of this case, my lord, if I just place to your lordship, it was a case wherein the widow approached and the employee, he was in ad hoc service. He was not regularized. if I just take to the facts of, my lord, it says Punjab Civil Service Rule so and so entitlement to family pension widows of ad hoc employees whose services continued from time to time for more than 1 year, whether their cases covered by para so and so of the scheme. Held the scheme is subject to and independent of the rules. Rules relating to pension apply to regular employees, not to ad hoc employees. Their widows therefore not entitled to benefit of family pension. The employees,
So you're also on the fixed pay.
I'm coming to that, my lord. The
Now, whether your period while you were working on as a fixed pay, was it a pensionable job?
My lord, the ratio of this judgment, with all due respect, the widows came before the honorable court in a situation that their service was never regularized.
No.
Yes, my lord. Their service were yet to be regularized, and they wanted that the ad hoc period.
No, that's why.
I'll just.
In this scheme also, which the Supreme Court dealt with, there was also the same criteria that you should complete 1 year service as a government employee. All right, you read para 39.
Yes, I'm just reading, my lord. The scheme in terms of para 3 is applicable to all the regular employees in pensionable establishment, temporary or permanent, who were in service. Thus, whether temporary or permanent, the employee must be a regular employee, which would mean an employee appointed on a regular basis, i.e. in accordance with rules, only because service of ad hoc employees were continued. Also, will kindly appreciate. Same would not mean that thereby their status has been changed, not regularized, that means. It will be a repetition to state that status of an employee can change either by reason of a contract or by reason of a statute. Nothing has been shown to us that the employee concerned either under the contracts of service or under any statute or statutory rules became regular employees of the state. So they did not become regular employees. They were still ad hoc when they approached the honorable court. So I became a regular employee subsequently, my lord.
Subsequently,
Yes.
You become a regular employee when? 26/7/2018.
Yes, my lord. It was regularized in the year 2018. I'll just take. If the scheme did not apply to the respondents, the provisions as to how the scheme would be administered are not of any significance. The contention that the family of an employee would be entitled to the benefit of family pension in the case of a death of a government employee, if he had completed a minimum 1 year continuous service without break, cannot be accepted. As stated herein before, an employee must be a government employee. At the first instance, he must be working in a pensionable scheme. Yes, my lord. He only in that capacity should have completed a minimum period of 1 year continuous service without any break, which would mean that he must be a temporary or permanent employee.
So para 39 is clear.
Yes. So
He should be working under a pensionable scheme.
He only in that capacity should have completed a minimum period of 1 year of continuous service without any break, which would mean that he must be a temporary or permanent employee. So continuous service without any break. He must be a.
Read the line before that.
Yes, my lord. I'll just read it again, my lord. As stated herein before, an employee must be a government employee at the first instant.
That is one.
I at the time of death,
You are a government employee.
I was a government employee.
No.
At the first instant, he must be working in a pensionable scheme.
Number two.
Number two,
So you're working under a pensionable scheme. Since when?
sorry, my lord.
You are working under a pensionable scheme.
Yes,
Or you're working for working.
the post
on
after
pension-
regularization, it
after-
was a pensionable scheme, my lord.
So after regularization, it was a pensionable scheme
So it's,
with effect from 26/7/2018.
my lord, I am not disputing that.
Hmm.
What the Supreme Court has said that first of all, he is to a government employee at the time of death. He has to be working in a pensionable establishment.
Number two,
Number two,
read
at the
next-
time of death,
read the next line.
yes, my lord. Pension, he only in that capacity should have completed a minimum period of 1 year of continuous service without break. So in that capacity, I have to work as 1 year continuous service without break, which would mean that he must be a temporary or permanent employee. So which would mean that he must be a temporary or permanent employee. So either in temporary or permanent capacity, I have to work 1 year continuous service
As a regular government servant.
as a regular government servant. Here, my lord, if I take your lordships to the advertisement and the factual background, if your lordships kindly come to page 29, it says that recruitment and filling up of the vacant post
Yes.
advertisement issued for recruitment and filling up of the vacant posts lying in the council, head of department, offices, district, sub-offices of BTC area as per details below. Post was junior assistant. Now, in the next page, if your lordships kindly take up H, it says candidates who are already engaged to the office of CHD district subdivisional offices on fixed pay basis by the BTC, either grade 3 or grade 4 also need to apply, meaning thereby the candidates who are working in these offices on fixed pay basis, they are also required to apply under this post because these are vacant posts. Had they,
Vacant post means what?
I
post?
understand, my lord,
This
the
is a sanctioned post or a non-sanctioned
my
vacant?
lord,
post?
scheme of the benefit which I am relying on, it doesn't say about, my lord, that person has to work in a vacant sanctioned post. It says only 1 year continuous service.
That's what the Supreme Court has clarified in 2008. That you should be a government employee, number one. That you should be working under a pensionable scheme, number two. And only those government employees should have completed 1 year of continuous service.
Lord, the case that I am placing before the lordships is that they have issued an advertisement against vacant posts. I am not going at all into the dispute whether those posts were vacant or sanctioned. That your lordship will see from the letters issued by the respondents given in mentioned in the order. Now they have issued a regular recruitment process, written examination, interview, followed by select list.
Then you are appointed on fixed pay.
They did not give me regular appointment. They kept me in a fixed pay post.
You did not agitate.
Not,
On that point, Lordship, I have placed another judgment, Lordship. That was a
Not-
grievance of the incumbent. Wife cannot be aggrieved by his appointment against.
Lord,
against
here
paragraph
I am
17,
not
Lordship.
making-
It's a more specific, Lord, paragraph 17. Her husband never raised that objection that why you are engaging me against a fixed pay post. Paragraph 17, Lordship, very small paragraph.
my submission, line of submission is little bit different, my lord. The dead person is not before your lordships, my
I
lord.
know.
My friend is making a submission that person should have come from heaven and prayed before your lordship.
no.
Regularization of his that period.
Before
Then-
he's dead, the petitioner's husband should have agitated, saying that, see, you have made an advertisement calling for applications to vacant post. Now you have appointed me to a fixed pay post. Correct. This is where the trouble starts.
So that
You are appointed to a fixed pay post. You never agitated, your husband never agitated at any point of time. He continued serving as a.
my lord,
a
he was
fixed
in,
pay.
my lord, he was in a lesser bargaining option, with all due respect. The husband cannot bargain with the authorities. My lord, Brojanath Ganguly lordship is aware that they have issued an advertisement. It's their duty to appoint him in that particular post, wherein for which the advertisement was issued. and they have appointed the petitioner in a fixed pay post. He did not have any bargaining option. He accepted it, my lord. Now that continued. Thereafter, they regularized his service. Now, I am on the point that this widow who is before your lordships, whether she can pay that earlier service, it's sort of only 6 months service is short. So whether that period can be counted as a qualifying service or not, the government servant has gone, my lord. He has gone. Now, the grievance of prayer number 2 and 3, lordships area, I am not on those two prayers, my lord. The petitioner's contention is that from 11 to 18, this 7-year service, whether this 6 months can be taken from that service and complete the qualifying service of 1 year, my lord. In fact, there are in the pension rule, there are, my lord, instances or office memorandum issued by the government wherein work charge service rendered by an employee, work charge mean working in a project. If the work charge service is continuous, that period has also been added while calculating 1 year service, my lord. I'll just take, my lord. So I am on a different projection. I am not on that period, previous service has to be regularized, and then I am not on that. The limited prayer of the petitioner before your lordships is that whatever had happened, this period has to be included within this qualifying service so that this lady with this two minor daughter, they can be, my lord, given the benefit of this compassionate family pension scheme.
That I've got your point.
Yes, my lord. And the scheme doesn't say that he has to be working in a sanctioned vacant post for 1 year. It says the government servant. That means if at the time of death, I am a government servant,
A regular government servant.
then I have to be in a continuous service of 1 year. It doesn't say that that particular service has to be in a pensionable, has to be in a sanctioned vacant post.
What do you say about the pensionable service?
My lord, so far as Supreme Court judgment is concerned, my lord, I haven't gone through it entirety. My lord, judgments your lordship is aware, my lord. Selective reading makes things difficult sometime, my lord. Prima facie reading, what my idea is that was a case wherein the widows, their husband's service were not regularized. They were still ad hoc. In that context, that remark came, my lord.
No. Here there was also a scheme which provided that 1 year continuous
Lordship will
service.
permit me to go through the entire judgment. I'll just try to satisfy your lordships, my lord. I'll just try to satisfy your lordships. In the meantime, lordship will also ask my friend, since your lordships wanted to have satisfaction with regard to the appointment order, ask my friend to bring those 2 letters. And in the meantime, I'll go through the judgment and I'll place the things properly before your lordships. Because sometimes it becomes difficult. I have para 39 I have seen, but in what context the para 39 ratio has been laid down, that also has to be seen, my lord.
Okay.
Because judgments I have also placed, my lord. 6, 7 judgments I have also placed, which supports my case. It says that if it's a continuous service, the term is continuous service, that period has to be counted. Office memorandum of the government of Assam is already there. If lordship wanted to see, my lord, one example I can give wherein government has already decided that the work charge service rendered by an employee has to be taken into account while calculating qualifying service. So work charge service is what, my lord? Work charge service is service rendered in a project. My position, wherein I have been selected by virtue of an advertisement appointed, you have kept me under fixed pay. I did not dispute. That's a different thing altogether. But my entry into the my lord, establishment, that was not backdoor appointment or something like that. It was pursuant to a due selection process. So I was in a better position than an work charge person. Work charge persons are taken from my lord, somewhere and my lord, interested in engaged in a project. If they have continued continuously, that period the government of Assam has recognized. I'll try to satisfy, my lord. I'll go through the judgment also, because I have some doubt regarding the applicability of those 2 paragraph.
There was a pensionable scheme, I mean, compassionate pension scheme. Which provided that 1 year continuous service as a government servant. Supreme Court made it clear,
Clinching difference is that they were yet to be regularized.
they were yet to be, here you were regularized, but within 4 months, your husband died, or
Yes,
4 or 5.
yes,
So you're shortage of somewhere about 6 or 5.
6 or 5 months. My lord.
Whatever it is.
So my argument therein is that, my lord, the previous service, which I have rendered in pursuance to a due selection process, you kept me in fixed pay, that's a different thing altogether. I cannot change that situation now. But that service has to be taken into account, at least, my lord, 6 month service has to be taken from that period. And, my lord, this benefit of the scheme has to be given, my lord. Your lordship's judgment, in fact, I have placed. আপনি argument করিব তো মই
Okay, we'll give you some time. Third H does, then
HK does.
HK does, then the counsel for the petition. Mr. P. Dayat, then the standing counsel BTC. Produce.
26 to Bulima 1 to
The letters. Shall produce the letter number. BTC within bracket E 221/2004 part dash Roman 1/1 dated 19/2/2011. Written by the Undersecretary, Personal Department, BTC, Khokraja, and the letter number BTC /trans TRANS -1/2004/105 dated 25/2/2011. Written by the Joint Secretary, Transport Department, BTC, Khokraja, which is reflected in the order dated 28 February 2011, within bracket, annexure P/5. Stop. How much time you require?
আপনি লোক mood problem নাই 2 weeks.
Okay, list the matter. I'll give a date.
Yes, my lord, that will be proper.
We'll have it on 14th of May. Okay.
Not.
List down
Fine.
14th May as part.
Deeply obeyed. Deeply obeyed.
Three,
Lordship, may kindly.
Wait, please, your lordship. My lord, the matter relates to retrenchment of the petitioners by the respondent corporation while they were serving under them. The writ petitioners had to approach this honorable court, my lord, apprehending a retrenchment exercise against them. And when the writ petition was filed, well, there was I'm placing the facts, my lord, very briefly. When the writ petition was filed, my lord, there was an order passed by this honorable court by observing that till the returnable date, no coercive measure should be taken against them. Your lordship will kindly find that order at page 45.
Age of
For-
the writ petition.
Yes, page 45.
Yes.
It is dated 6th of October 2016. Well, the very brief order, my lord, leased on 2/11/2016, enabling Miss R. Devi Learned Counsel representing the Union of India to obtain instructions in the matter. Until the next date, no prejudicial action be taken against the petitioners. That was the observation made. Well, despite this order having been passed in presence of the counsel for the respondents, my lord, eventually a retrenchment order was passed. That was on 14th of October.
Age.
That your lordship will find at page 46A, 46B, and 46C. Three orders in respect of three petitioners.
46.
46A, the very next page.
What?
Forty-six A, B, and C
Of the writ petition, isn't it?
of the writ petition. My lord, the writ petition had undergone amendment, my lord. The consolidated brief was filed thereafter.
Okay.
46A, your lordship has found.
Amended writ petition.
Yes, my lord. It was marked in seriatim. Page 45, your lordship has seen the interim order, my lord. Thereafter, page 46, the further order dated 21st of 11/2016.
Page 46.
Annexure 16.
Yes, that is another order.
Another order continuing the interim order passed earlier.
Yes.
And thereafter, next page, your lordship will find 46A.
I have 47.
My lord, may I just find it out for your lordship?
Yes.
Huh? কি ফাইল করেছে কি? অদ্ভুত দামকার person. Wow, file. Amended writ petition.
You have Devi?
No, Lordship.
Well, actually, these orders were provided by them only, my lord. Consequently, the petition was amended. At the beginning, my lord, these orders were not with the writ petitioners. During the course of proceeding, my lord, they submitted it.
No, that's fine. That means you have filed an amended writ petition.
Yes, I filed an
But
amended writ petition, my lord.
according to that pagination, 46 is that the order passed by this court?
Yes.
45 also?
Well, I'm just finding it out. It's somehow it has got mixed up in the brief. File করে দেবো। 45, 46,
Hanikar, you have,
47 is
you have 46A.
Sometimes, somehow it has been probably misplaced in this brief, my lord. I'll just,
Is there another file? Just check up in the court.
second file to the other side, sir.
What it is,
Maybe, my lord, it has not been placed on this file. नहीं देखने रहा.
just see if 46A is there.
It is there, my lord. This is, it got mixed up, my lord. It has been marked as 47A, 48A and onwards. The marking is little different here.
No.
This is the page, my lord.
So how do you rectify this?
The page number has been different, my lord, but otherwise the papers are there. Actually, the original order has been placed at that page 47, but the typed copy, I was referring to the typed copy. This is page 47, lordship. Now, this is, your lordship will note on the top, my lord, 14th October 2016.
Yes.
Now, this is the order by which the petitioner number was 1 was retrenched. The order reads like this, my lord. By reference on the captioned subject, it was circulated that Union Cabinet approved dissolution of CIWTC on 31/8/2016 and improved VRS was again offered for the remaining 5 numbers of employees of CIWTC on roll for a period of 1 month to opt for, and in the event of non-opting, the improved VRS retrenchment under 1997 scale would be implemented. It is noticed that you have not opted for improved VRS within the time period of 30 days from the date of issue of the notice expired on so-and-so, issued in terms of Union Cabinet decision referred to above. Accordingly, in terms of the Union Cabinet decision referred to above, you are hereby retrenched from the services of the corporation from 14th October 2016. And 1997 pay scale CRS would be implemented for settlement of dues on retrenchment in terms of Union Cabinet decision. So this is the retrenchment order. And similar is the retrenchment order in respect of the other 2 employees, the subsequent 2 pages, my lord. Subsequent 2 pages on your lordship's brief, the retrenchment order in respect of the employees. Now, what has happened in the case, my lord, after the petition was being moved and the interim order was passed, it was proceeding like that. But at one point of time, my lord, it was the stance taken by the respondents. When I raised a claim, we raised a claim for payment of salary and other all. Then the respondents had put forth a representation before the honorable court that the petitioners had already stood retrenched. Then at the direction of the honorable court, my lord, the honorable court passed the direction on 19th of May 2023 to file an affidavit on this aspect of the matter. Consequently, my lord, the retrenchment orders were brought on record and we amended the writ petition to challenge these orders. So basically, my lord,
How many retrenchment orders are 4?
3. There are 3 petitioners, my lord. There are 3 orders.
MD Ibrahim.
One retrenchment order I have read out to your lordship, my lord. That is at page 47. Your lordship has seen.
Okay. One is a type copy.
One is a type copy. So there are 3 retrenchment orders. Now, during the course of proceeding, my lord, the honorable court passed a direction asking them to inform the honorable court about the status of the case. I mean, the status of the corporation under which we were working, because we have raised 2 kinds of grievances. First of all, that the retrenchment order is invalid and it needs to be set aside and quashed. And secondly, we need to be taken back either in the department which is functioning on paper, maybe, or to the corporation to which the assets of this corporation has been transferred. So there was a decision because we were working under Central Inland Water Transport Corporation. And following a decision of the Union government, my lord, the assets of CITWC was transferred. to another authority, namely Inland Waterways Authority of India. So our twofold prayer before the Honorable Court has been that either to set aside the order of retrenchment and take us back either to the CITD of the sea or to the organization to which the assets and assets of the corporation has been shifted. Now, after when these deliberations were going on, my lord, they have come up before the Honorable Court by submitting an affidavit, and there they have made a disclosure that in fact this was an order of retrenchment passed against us, and the benefits that would be payable to us in terms of Section 25A of the Industrial Disputes Act will be released to us. So, in view of that submission, that affidavit coming on record, my lord, in my further reply, my lord, I had brought on record the fact that emerges is that basically before this retrenchment order was passed, these three orders were passed because Section 25F of the Industrial Disputes Act lays down certain procedures to be followed. There are certain preconditions which are required to be fulfilled. Admittedly, my lord, none of these preconditions have been fulfilled in the present case. That I'll perhaps, my lord, your lordship will be taking a.
Yeah, five minutes.
Yes. Two 2023.
Yes.
I'll just read from paragraph 3, my lord. That will make the issue very apparent. The issue involved in the instant writ petition is that the respondent number 2 organization had initially floated a voluntary retirement scheme. However, as the terms and conditions of the voluntary retirement scheme were not acceptable, a fresh, improved voluntary retirement scheme was floated in the year 2015. Out of 272 numbers of employees of the respondent number 2 organization, 267 employees were given the IVRS, that is Improved Voluntary Retirement Scheme. However, 5 employees did not accept the IVRS. Out of these 5 employees, the petitioners happens to be the 3 employees who have not taken IVRS. The Learned Counsel for the respondent number 2 and 3 submits that as it would be apparent from the affidavit in opposition filed by the respondent number 2 and 3, as well as from the additional affidavit that in view of the directions issued by the Public Enterprise Department so-and-so, these 5 employees who have not accepted IVRS were retrenched without giving any benefits. Your lordship will kindly mark this sentence below. Retrenched without giving any benefits. This court had put a specific query upon the Learned Counsel appearing on behalf of the respondent number 1 and 2, 1 as well as upon the current counsel appearing for the respondent number 2 and 3 as to whether the petitioners herein would be entitled to any compensation in view of their retrenchment, and further whether the petitioners now cannot be given the same benefits which have been already given to those 267 employees. The counsel appearing on behalf of the respondent seeks for an accommodation to obtain instructions. Then thereafter, well, the case is adjourned to a further date. And thereafter, the affidavit comes, an affidavit comes from them, my lord, which is dated dated 5th of June. That your lordship will find possibly, my lord, it has been placed on the top of the lordship's brief.
Top of the brief.
Maybe on the top of the brief, my lord. Although it has been marked as page number 268, but it appears to be on the top of the brief. From the second copy, my lord, I have seen. It's an affidavit dated 29th of May, but filed on 5th of June, say 7th of June.
Just give the page number.
It is marked as 268. In the second copy, my lord, that is on the top of the brief.
One Sandeep Gupta.
Yes, my lord.
Yeah.
Now, in this affidavit, your lordship may kindly come to paragraph 5, which is at page 270. Has your lordship got it?
Yes.
Where that when the matter was listed on 19/5/2023 for admission hearing, the Honorable Court has sought instruction from the respondent authorities as to whether the petitioner should be entitled to any compensation in view of their retrenchment, and further, whether the petitioners now cannot be given the same benefits which have already been given to those 267 employees who are given the IDRS. So that is just the quotation of the order, my lord, which I have read out to your lordship. The paragraph 6 is important, my lord. In response to the aforesaid query of the Honorable Court, the deponent begs to state that the petitioners, being the retrenched employees, the necessary of the Central Inland Water Transport Corporation, CIWTC, necessary action in respect of them will be taken up as per Section 25F of the Industrial Disputes Act. And compensation equivalent to 15 days of average pay for every completed years of continuous service or any part thereof in excess of 6 months may be paid to them. So this is their stand coming on record, that in view of Section 25F of the Industrial Disputes Act, the benefits will be calculated and paid to us. Now, if that be the case, then, my lord, necessarily the question falls for consideration is whether this retrenchment order is valid because of the fact that admittedly no benefits have been given to us. And Section 25F is very categorical as to how an order of retrenchment is to be passed. I'll just place before your lordship the provision of Section 25F. Page 64, perhaps. Conditions precedent to retrenchment of workmen. Has your lordship got?
Yes.
No workman employed in any industry who has been in continuous service for not less than 1 year under an employer shall be retrenched by that employer until the workman has been given 1 month's notice in writing indicating the reasons for retrenchment, and the period of notice has expired, or the workman has been paid in lieu of such notice wages for the period of the notice. First condition is that they have to serve a notice, they have done it. As per the impugned order itself indicates that there was a notice. Now the second part, the workman has been paid at the time of retrenchment compensation which shall be equivalent to 15 days average pay for every completed year of continuous service or any part thereof in excess of 6 months. Now this part they have not complied with, because their affidavit is very categorical, which I have just now read out to your lordship, that this benefit is yet to be released. This benefit, as is comprehensible under 25FB, that has not been paid. And there is a further requirement, that is clause C. Notice in the prescribed manner is served on the appropriate government or such authority as may be specified by the appropriate government by notification in the official gazette. So not only that the notice has to be given to me, at this time of serving notice, I will also have to be paid the retrenchment compensation, which is clause B. And clause C is that a notice has also to be submitted to the appropriate government. That can be either Union of India or the state government, as the case may be. But in the instant case, it will be Union of India. So these are the 3 conditions which are required to be satisfied, which are the preconditions, which are required to be satisfied before an employee is retrenched under 25A. Admittedly, my lord, none of the conditions have been, except for clause A, none of the conditions have been satisfied. That is the present status of the case. Now, therefore, my lord, necessarily the question would arise that if the retrenchment order is in violation of 25F, my lord, admittedly, my lord, since the other 2 conditions have not been complied with, so there is a violation of clause 25A, section 25A. So naturally, my lord, the question that arises is, since there is a violation of section 25F, whether the retrenchment order can sustain, number 1. If the retrenchment order cannot sustain that, what consequence should follow from it? Well, I'll place 2-3 decisions, my lord, on this line. First of all, I'll place one judgment, my lord, to show that even the clause C, which is a requirement of sending a notice to the appropriate government, my lord, that is also a mandatory condition. That also cannot be waived out. And admittedly, my lord, as per their affidavit goes, the latest affidavit goes on record. Well, admittedly, my lord, neither the retrenchment compensation has been paid, not to speak of any filing of any notice to the appropriate government. So, admittedly, this shortcomings in the entire exercise renders the retrenchment order dated 14th October 2016 void ab initio. That is my first submission, my lord. Now, to take your lordship to the next course of submissions, my lord, I will just place. First, I will place a decision of Honorable Supreme Court, my lord, in the case of Rajkumar versus Director of Education. Your lordship will kindly.
One.
Well, I'll also supply the copy.
Yes.
2016 sub. I'll first read from paragraph 12, my lord.
This 2016.
This is 2016 6 SSC, page 541.
Para.
I'll start with paragraph 12, my lord. Para 12, 13, 24, 25.
Yes.
34, 35, 38, 56, and 57. 34, 35, 38, 56, and 57. Now, paragraph 12, my lord, that will appear at page 548. On the issue of notice being served on the appropriate government in the prescribed manner, the tribunal placed reliance. Here was a case, my lord, the matter was before the labor tribunal. The tribunal took a view that the requirement of placing this notice, as is under clause C, that is not a mandatory precondition. That was the view taken by the tribunal. So the matter went to High Court. High Court dismissed the writ petition, and eventually it was taken up before the Honorable Supreme Court. On the issue of notice being served on the appropriate government in the prescribed manner, the learned tribunal placed reliance on the decision of this court in Bombay Union of Journalists so-and-so, wherein it was held that this was only directory in nature and not a condition precedent for retrenchment. This court held as under. Lord, thereafter it is quoted. I'll not trouble your lordship with this, my lord. I'll eventually go to the final determination, which your lordship will find at page page 555, paragraph 34. I'm just indicating this, my lord, to give the preface of the case. Page 34. We are unable to agree with the reasoning adopted by the tribunal as well as the High Court in the instant case. Admittedly, the notice under Section 25C of the ID Act has not been served upon the Delhi state government. In support of the justification for not sending notice to the state government, reliance has been placed upon the decision of this court in Bombay Journalists. This decision was rendered in the year 1963, and it was held in the said case that the provisions of Section 25FC of the ID Act are directory and not mandatory in nature. What has been ignored by the tribunal, this is important, my lord, this sentence. What has been ignored by the tribunal as well as the High Court is that subsequently Parliament enacted the Industrial Disputes Amendment Act 1964. Section 25C of the ID Act was amended to include the words on such authority as may be specified by the appropriate government by notification in the official gazette. The statement of object and reasons provides opportunity has been availed of to propose a few other essential amendments which are mainly of a formal or clarificatory nature. Nothing was done on the part of the legislature to indicate that it intended Section 25FC of the ID Act to be a directory provision, when the other two subsections of the same section are mandatory in nature. The amendment was enacted which seeks to make it administratively easier for the notice to be served on any other authority as specified. Next, after quoting the provisions of, after quoting the relevant paragraph of Bombay Journalist case, my lord, the next page, Thus, this court read the ID Act and the relevant rules thereunder together and arrived at the conclusion that Section 25C is not a condition precedent for retrenchment. By no stretch of imagination can this decision be said to have held that there is no need for industries to comply with this condition at all. At the most, it can be held that 25FC is a condition subsequent, but is still a mandatory condition required to be fulfilled by the employers before the order of retrenchment of the workmen is passed. So admittedly, my lord, that requirement has not been completed in the present case. Thereafter, how the Honorable Court in page 38 has also, paragraph 38 has also referred to the industrial disputes rules, which lays down the procedure how the notice is to be served. And the relevant observation which has been made thereafter will come at page 56. That will be at page 564, paragraph 56.
Yes.
The termination of the appellant is bad in law for non-compliance with the mandatory provisions of Section 25F of the ID Act and also Section 82 of the DSE Act. Well, there is another act that was applicable here. Further, the respondent school has not produced any evidence on record to show that the retrenchment of the appellant was necessary as he had become surplus. The termination of the appellant was ordered in the year so-and-so and he is unemployed till date. The respondents have been unable to produce any evidence to show that he was gainfully employed during that period and therefore he is entitled to back wages and other consequential benefits in view of the law laid down by this court in Dipali Gundu Survase case. The page next, my lord, paragraph 57. For the reasons stated supra, we are of the view that the impugned judgment and order dated so-and-so passed by the Delhi High Court is liable to be set aside and accordingly set aside. By allowing this appeal, the retrenchment of the appellant from his service is bad in law. The respondent managing committee is directed to reinstate the appellant at this post. Consequently, the relief of back wages till the date of this order is awarded to the appellant along with all consequential benefits from the date of termination of his services. Back wages shall be computed on the basis of periodical revision of wage and salary, etc. So therefore, my lord, what emerges from this decision is that if there is non-compliance of the provision of 25A, which is admittedly there in the present case, my lord, the retrenchment order has to go. And in ordinary course of thing, my lord, the reinstatement has to be ordered with full back wages. But here is a, my lord, peculiar case in a sense that the particular organization in which the petitioners were working, my lord, that has been merged or in a sense, my lord, the assets of that corporation has been diverted to the assets of another corporation. And that is the reason, my lord, that the provisions of IVRS was floated, which the petitioners had not accepted at that relevant point of time. But regardless of this situation, my lord, the fact remains that these 3 retrenchment orders dated 14th of October 2016, well, these have been passed in utter disregard to the provisions of Section 25A. Even their own affidavit shows that even the compensation which is required to be paid in terms of 25FB, that has not been paid. So, my lord, my first limb of submission will be that this order of retrenchment should go and the consequential actions need to be ordered. Now, there is another case, my lord.
Yes.
There is another case, my lord, where, my lord, which, my lord, I would submit before your lordship. That is reported, that is also a reported case from Supreme Court, my lord. There also, my lord, the question of retrenchment stood for consideration before the Honorable Court. And ultimately, my lord, after discussing very many aspects of the matter, my lord, paragraph 13, your lordship may, paragraph 13 particularly, your lordship may take into account. The last, after discussing the precedents on the subject, my lord, on the issue, the last sentence, my lord, we hold as a result of our discussion that discharge of the workman on the ground that she did not pass the test which would have enabled her to be confirmed was retrenchment within the meaning of Section 200. There it was disputed whether the order of termination passed against the workman was retrenchment or not. That was the issue basically. But ultimately, the court found that it will fall within the meaning of retrenchment under 200, and therefore, my lord, this observation came in the last page. Your lordship will find within the meaning of section 200, and therefore the requirements of 25F had to be complied with. The order of the presiding officer, central government industrial tribunal comes so and so is set aside, and the appellant is directed to be reinstated with full back wages. So the theme remains the same, my lord. If the retrenchment order is in violation of section 25F, then it must go, and the natural consequence will be reinstatement with full back wages. But then, my lord, over a period of time, this has undergone some change. I must candidly admit before your lordship. Nowadays, there is also a view that if for some reason the reinstatement is not possible, then in the alternative, a compensation can also be awarded. But at any rate, my lord, the retrenchment order is liable to be set aside. In a latest decision, my lord, 2003, my lord, the Honorable Supreme Court had found that the retrenchment orders were bad. And therefore, the Honorable Court directed that the persons be taken on roll again, and they can be retrenched only after by complying with the provision of 25A. So therefore, in the present case, my lord, my submission will be that if the retrenchment order of 2016 goes, they will have to be notionally deemed to be in service even on this date, as on this date. And if the authorities now want to take the course of 25F, they can very well do so, my lord, but they will have to first comply with the provision of 25F. They will have to meet the preconditions that have been enlisted in 25F. But I am placing just that judgment. 2003. 2003 4 SCC 27. Paragraph 9, 12, 14, 16, and 20. May I start? 9. Let it be stated that on the material available, we are not inclined to upset the finding of fact arrived at in the interim judgment that the appellant workmen are project employees and not employed in any department. It was a case, my lord, where the employees concerned were not even permanent employees. They were working in a project. They were working in a project, not even a permanent employee, which we used to be in the department, under the respondent. Even then, my lord, this observation has come. The principal issue argued by the learned counsel for the parties centers around the status of project or the scheme employees. Whether the workmen recruited for discharging temporary job under a project can insist on compliance of section 25F of the Act if their services are dispensed with on the project coming to an end. Next, your lordship can skip to paragraph 12. Retrenchment, next page. Retrenchment in its ordinary connotation is discharge of labor as surplus, though the business or work itself is continued. It is well settled by a catena of decisions that labor laws, being beneficial pieces of legislation, are to be interpreted in favor of the beneficiaries in case of doubt or where it is possible to take two views of a provision. It is also well settled that Parliament had employed the expression the termination by the employer of the service of a workman for any reason whatsoever, while defining the term retrenchment, which is suggestive of the legislative intent to assign the term retrenchment a meaning wider than what it is understood to have in common parlance. There are 4 exceptions carved out of the artificially extended meaning of the term retrenchment, and therefore termination of service of a workman, so long as it is attributable to the act of the employer, would fall within the meaning of retrenchment, dehors the reason for termination. To be accepted from the meaning of retrenchment, the termination of service must fall within one of the 4 accepted categories. A termination of service which does not fall within categories A, B, BB, and C would fall within the meaning of the word retrenchment. Now, retrenchment is defined in section 200 in the ID Act. Next, here, paragraph 13, the termination of service of a workman engaged in a scheme or project may not amount to retrenchment within the meaning of subclause BB, subject to the following conditions being satisfied: that the workman was employed in a project or scheme of temporary duration, the employment was on a contract and not as a daily wage or simpliciter, which provided inter alia that the employment shall come to an end on the expiry of scheme or project. The employment came to an end simultaneously with the termination of the scheme or project and consistently with the terms of contract, and the workman ought to have been apprised of or made aware of the above said terms by the employer at the commencement of the employment. Next, paragraph 14. The engagement of a workman as a daily wager does not by itself amount to putting the workman on notice that he was being engaged in a scheme or project which was to last only for a particular length of time or up to the occurrence of some event. And therefore, the workman ought to know that his employment was short-lived. The contract of employment consciously entered into by the workman with the employer would result in a notice to the workman on the date of commencement of the employment itself that his employment was short-lived, and as per the terms of the contract, the same was liable to termination on the expiry of the contract and the scheme or project coming to an end. The workman may not therefore complain that by the act of the employer, his employment was coming to an abrupt termination. To exclude the termination of a scheme or project employee from the definition of retrenchment, it is for the employer to prove that the above said ingredients so as to attract the applicability of subclause BB above said. Now, here it is not even a case where it is disputed that the case of the petitioners were not of retrenchment. It is admittedly a case of retrenchment, and therefore, my lord, the exceptions that have been discussed here in the preceding paragraphs, my lord, that will not get attracted. But still, my lord, I have read this out to your lordship just to impress upon the honorable court that even in a case where, my lord, it was disputed whether or not it would come within the framework of the definition of retrenchment, my lord, the honorable court had found out that unless the tests are satisfied, my lord, it will still be regarded as a retrenchment. And what will be the consequence, as I said earlier, my lord, if the retrenchment is found to be invalid because of infraction of section 25F, then what will be the consequence that will ensue on the respondent? Now that your lordship will find at paragraph 16. It is pertinent to note that in Hari Prasad Shivsankar Shukla versus so-and-so, the Supreme Court held that retrenchment as defined in section 200 and as used in section 25F has no wider meaning than the ordinary accepted connotation of the word, that is, discharge of surplus labor of staff by the employer for any reason whatsoever other than by way of a punishment inflicted in disciplinary action. Retrenchment was held to have no application where the services of all workmen were terminated by the employer on a real and bona fide closure of business or on the business of undertaking being taken over by another employer. The above said view of the law taken by the Supreme Court resulted in promulgation of the Industrial Disputes Amendment Ordinance number so-and-so with effect from so-and-so, and later on replaced by an Act of Parliament with effect from so-and-so, whereby section 25FF and section 25FFF were introduced in the body of the Industrial Disputes Act. 25FF deals with the case of transfer of undertakings with which we are not concerned. 25FFF deals with closing down of undertakings. The term undertaking is not yet defined in the Act. The relevant provisions use the term industry defined in the Act. The relevant provisions, undertaking is a concept narrower than industry, and undertaking may be a part of the whole, that is the industry. It carries a restrictive meaning. With this amendment, it is clear that closure of a project or scheme by the state government would be covered by the closing down of an undertaking within the meaning of section 25FFF. The workman would therefore be entitled to notice and compensation in accordance with the provisions of 25F, though the right of the employer to close the undertaking for any reason whatsoever cannot be questioned. Next, paragraph 20. During the course of hearing, during the course of hearing, it was stated at the bar that there are a number of matters pending in different fora, industrial labor court or high court, raising similar issues awaiting decision in the case. We clarify that all such pending cases shall be heard and decided in accordance with the law as stated herein above. The project in which this is important, my lord, the project in which the workmen were engaged has come to an end. the respondent government may consider the appellants being accommodated in some other project or scheme or regular employment, if available, by issuing suitable instructions or guidelines. If it be not possible, the respondents shall be at liberty to terminate the employment of the appellants after reinstating them as directed by the High Court and then complying with the Section 25F of the Industrial Dispute Act. So therefore, my lord, taking a cue from this, my lord, my submission before your lordship is that since, my lord, evidently there is violation of 25F in issuance of the retrenchment order, my lord, the retrenchment order has to go. And the possible consequence that may ensue on the respondents is that they will have to deem the petitioners to be in employment till the time they fulfill the exercise as contemplated under Section 25F in letter and spirit. Because their affidavit is very much clear that exercise under 25F have not been undertaken. So this is precisely my case. So on this factual scenario, my lord, I will humbly submit that your lordship will pass an order setting aside the order of time. And another aspect which is very important, my lord, your lordship, I have at the beginning shown on 6th of October itself, immediately after the notice was served on me, I had approached this honorable court, and this honorable court passed an interim order. For some reason, my lord, there appears to be a communication gap between the counsel and the client, my lord. Of course, it is a plea taken in the affidavit now that although the counsel was there in the case, the counsel did not communicate the matter to the respondent corporation, and consequently 14th October order was passed. But regardless of the fact that fact, my lord, the records clarify this position that as early as on 6th of October, my lord, there was an interim order in my favor, which protected me from any coercive action being taken against me by the respondent corporation. So if that order of the honorable court is to be respected and honored, my lord, then admittedly this is yet another ground, my lord, for which, my lord, 1410 retrenchment order will stand as void ab initio, because their hands were tied. So
Interim order is dated
6th of October 2010, that is at page 45. And the retrenchment order is 14th of October. And this 6th October order was again renewed on 21st of November 2016. And even on that day, my lord, no disclosure came before this honorable court that the employees were already terminated. I mean, already retrenched. Page 46, this subsequent order, your lordship will see.
Let us see that. Retrenchment order.
Page 45 is the first order, my lord. Or it will be in the order sheet also, my lord. 6th of October 2016. Page 45, annexure 15.
The retrenchment order.
Oh, retrenchment order will be at page 47. Huh? 47. It starts from 47, 48, 49. It's dated 14th of October.
Two thousand
16. Although, my lord, our plea remains on the record that we never received this order, but they have submitted before this honorable court the postal receipts to indicate that it was addressed to us. The postal receipts.
Interim order was renewed on.
Interim order was on 6th of October.
Yeah. After that, it was renewed on.
It was renewed on 21st of November 2016. And even on 21st of November, my lord, there was no disclosure by the counsel of the respondents that by that time already interim or retrenchment order had been passed. The 2111 order, your lordship will find at page 46.
Okay.
That's my case.
Devi, you are appearing for?
For one lot. For 20.
For all practical purpose, my lord, it will be respondent number 1 now. Because of the developments that have taken, that one undertaking has been shifted to another. It will be on respondent number 1 now.
All matter diabetes and matter diagnosis already shifted.
Whatever it is.
Already handed over to matter. Java Pahat Partuko. Now, matter practically CIWT has no existence. CIWTC has right now no. All the assets and liabilities are already handed.
So supposing data, if an order is passed, to whom should the order go?
My lord, I'll submit that it will go to all the respondents. Because Union of India cannot shirk off its responsibility at any circumstance, number 1. Number 2, CITWC is still being managed by an official, my lord, for the purpose of completion of the taking over and handing over and taking over of the assets. One person is still there. So it is not that the CITC does not exist on the official records. CITWC is still on official records. And number 3, my lord, even if the submission from the CITWC is taken into account that their assets have been transferred to some other entity, which is also the respondent number 3 in the case, in that case, they should take the responsibility. And all these 3, that is number 2 and 3, respondents number 2 and 3, they are only agencies of the Union of India. They are arms of Union of India. So ultimately, the responsibility has to be taken by respondent number 1. But in any case, my lord, the order of retrenchment is plainly, my lord, that is unsustainable. And after this affidavit, which this gentleman Sandeep something had filed, I had filed a supplementary affidavit, my lord, saying 2 things, that not only the retrenchment compensation was not paid, the notifications were also not done, and we have also not been gainfully employed. There is no counter to that. So that the factual situation remains the same.
Lordship, in compliance of 25F, Lordship, notice was issued to the respondents. 1 month notice was issued requesting them to opt for the improved voluntary retirement scheme, Lordship. All other employees have accepted this scheme, except these petitioners and 2 others, Lordship. And after completion of this 1 month period, they were returned since they have not accepted this scheme, Lordship.
What about the other conditions?
Other conditions regarding Lordship payment of compensation, Lordship, it is since this repetition is pending, Lordship, in this period. And it is stated that
See, one side you are saying writ petition is pending, so you have not paid it. On the other side, you've issued the retrenchment order.
Lordship, in this affidavit, it is stated that they will, whatever they are entitled to, Lordship, as per 25F, they will be paid, Lordship.
Can you do that after the retrenchment order or before issuing the retrenchment order? This is the answer you have to give.
After retrenchment.
How can you pay after the retrenchment, pay the compensation after retrenchment order? Prior to issuance of retrenchment order, you have to fulfill
Notice is
25,
required, Lordship. Prior
25F, 3
Not-
conditions are required.
notice is required.
First
before
thing is notice,
notice.
number 2 is
Second is the
compensation,
compensation.
number 3 is notification. Have you done this too? Okay, let us accept that notice has been issued. Notice has been given to the
Issued, Lordship. And as per my affidavit, Lordship, they are, whatever they are entitled to, they will be given, Lordship.
Can you do that after the retrenchment?
Yes, Lordship, as per
How?
25 doesn't say that compensation has to pay before.
Let us read 25F properly.
Yes, condition precedent.
You have a copy of the Industrial Disputes Act.
No, Lordship. Yes, Lordship. B, the workman has been paid at the time of retrenchment.
Read the first line, 25F.
Lordship. Notice, Lordship.
No, above notice.
Yes.
No work.
No workman employed in any industry who has been in continuous service for not less than 1 year under an employer shall be retrenched by the employer until the workman has been given 1 month notice in writing.
That you have done.
Yeah, I have done, Lordship.
Then
The
B,
workman has been paid at the time of retrenchment, compensation which shall be equivalent to 15 days average pay.
then C.
See, Lordship, I am not aware of, Lordship, whether it is issued or not, but notice.
This has not been issued. Even if you have issued in C, since you have,
There is still non-compliance of B.
there's still non-compliance of B. So the automatically retrenchment order has to go.
Yes, sir, not given at the time of retrenchment, but
Till now, you have not
They
given
will be
them.
given
Till
lot.
now, you have not given them.
yes, Lordship.
So how can you issue the retrenchment order?
On the last occasion, Lordship, on 19.5 order, it was confined only whether they are entitled to at this stage, Lordship.
So this court
Yes,
asked the query whether
not,
the
not on the
five
retrenchment.
persons, here there are only 3 writ petitions.
Yes, three.
2 has not come.
Yes.
So out of the 5,
Yeah.
whether they can also be accommodated in terms of the other
Other schemes and all.
Yes,
IVRS.
yes,
All right.
Lordship.
So you said, no, we cannot do it. But then in terms of section 25F of the Industrial
They are
Dispute Act,
entitled to
they will
compensation.
be entitled to compensation.
Not-
So you've not done it.
And notice, Lordship, to be honest, I don't have any instruction, Lordship, regarding notice.
Whatever it is notice, whether you have done it or not, that's a different issue.
No.
But on the basis of section 25FB, this retrenchment order has to go.
That is their own admission in the affidavit.
Yes.
It has not been paid.
Paragraph 6, isn't it?
Yes. Paragraph 6.
And also, Lordship, it is not, notice was not on, not under, their retention order, Lordship. It is not under 25 F. It is not mentioned.
You're going around,
Yes, but-
going around, saying notice not under 25F, so
But
therefore,
the retrenchment order was issued by the CIWC.
whatever it is,
Instead of they were requested to accept the IVRS scheme on 2 occasions. Either you accept the IVRS scheme or you will be retrenched. That was the final notice.
that's fine.
That's fine.
Either you accept IVRS or you will be retrenched.
Or you will be retrenched.
So they did not accept IVRS.
And
So,
this
well,
retrenchment,
then-
the retrenchment order was not issued in compliance of section 25F according to CIWC retrenchment.
But what does the,
The
what does the
central government-
affidavit
now
say?
what the central government said that this was issued in compliance of 25.
Then you've got nothing to say on that.
Benefit will be, it is, as per my affidavit law, the benefit will be given as per section.
You are putting the cart before the horse.
Lordship.
That's the whole thing.
Lordship. And another issue, Lordship, at this later stage, I am raising it, Lordship, whether it is maintainable in the 226, Lordship, since they have challenged the retrenchment, Lordship, under the Industrial Dispute Act.
Have you taken that ground?
No,
Yeah,
earlier it was not taken, Lordship.
Then on what basis
Yes.
can you argue?
But otherwise also under the Industrial Dispute Act, Lordship, it's maintainable. There is a provision,
You've not taken the ground,
yes, Lordship, at the initial stage it was not taken.
then
Because at the initial stage, Lordship, only notice was challenged. Later on it was returned.
see, notice was challenged. This court passed an interim order
Fix them,
not to take any coercive steps
Yes,
against
Lordship.
this.
14
Correct.
ten.
And if I remember correctly, my lord, she was there for the respondent.
I was there.
She was there for the respondents on the,
But then
Till,
you issue the
He has
retrenchment.
not communicated here.
That by itself is violation of this court's interim order.
okay.
On that basis itself, this retrenchment order has to go.
Madam,
Number
that
two, no,
that issue was madam, already madam, told madam, that the IA number madam, 112. The petition has filed an IM. That is 112 2017. And that I was already closed. Madam.
What IA?
No, the IA was filed seeking release of the salaries and other allowances, because since there was an interim order,
Even they have not
they
filed
were-
any contempt.
they were
contempt
supposed
proceeding.
to give us the salary and allowances, so IA was filed. But after the disclosure came from them in the IA that they had retrenched, because we were not aware of it. Otherwise, why we came before the honorable court challenging the notice? Why would we not challenge the retrenchment order? It was their disclosure in the IA from where we came to learn that there was already an order of retrenchment. That's why it was challenged. Otherwise,
Then-
your lordship will see 2016 matter.
And
It's a
madam,
pretty old matter.
Amendment.
And therefore, the
That-
we amended
that
the
matter
retrenchment.
already-
So what do you say?
Lordship. Since the lordship, CIWTC does not exist, and it is not that they were, allowed to go on without any competition. They were given improved voluntary retirement scheme. All the employees have accepted except this petitioner's option. And therefore, there is no option other than to return them.
That's fine, that's
Yes,
fine. We're not saying
and-
you can't
and-
retrench them. We're not saying you can't retrench them.
And
All right.
also lordship, they will be given the compensation.
That
Yes,
is the issue. That
issue,
is the
yes,
issue
lordship.
involved.
At that time.
You can't pay
at
the
that-
compensation after retrenchment.
Yes, at
You have to pay compensation before
time-
retrenchment.
at the time of retrenchment.
And whether notice was issued, was given in the official
See.
gazette.
It was not given. It has not been given. To my instruction, my lord, it has not been given. There is also no disclosure from their affidavit that notice was published in official gazette.
Have you published a notice in the official gazette?
No, it is lordship, not in my instruction.
Because we specifically urged this point, my lord, in the supplementary affidavit that we filed on 20th of July 2023. 20th of July 2023, we filed a supplementary affidavit, my lord, and in supplementary affidavit, we have specifically raised that point.
28 of
2027-2023. Paragraph 3, your lordship will see in that note, in that affidavit. Supplementary affidavit on 27-2023. Paragraph 3. From the statements made in paragraphs 4 and 6 of the instant affidavit, it is evident that though the petitioners have been allegedly retrenched on 14/10/2026, the compensation as payable to them in terms of 25F have not been paid to them, nor any notice has been served on the appropriate government. And then down below next paragraph, we have said petitioners have been illegally retrenched, and as such the retrenchment orders dated issuance were liable to be set aside. Be it also stated that the petitioners, despite existence of an order of stay from this honorable court dated 6th of October 2016, have not been paid any service benefits including salary. Petitioners have also not been gainfully employed and have been surviving at the mercy of well-wishers and relatives. If they want to deny me now back wages, it is burden is on them to prove that we are gainfully employed. That is the judgment, Lord, I have submitted.
Yes, what do you have to say on para 3 and 4 of the supplementary affidavit? You have not filed a reply.
Not filed lordship. But the fact remains that lordship, this retrenchment was not under 25 lordship, but we have admitted that under 25 F, whatever compensation.
Obviously,
entitled
that
to.
automatically goes to show that the retrenchment order was passed under 25F.
Then since they are
So when you pass an order of retrenchment under, when you say that they will be given the benefits under
Benefit.
25FB,
But benefit has to
compensation.
be paid under some provisions, Lordship. Therefore, under section 20.
So when you are when you are invoking 25FB
Lordship,
to pay the compensation amount, automatically it implies that retrenchment order was passed under 25F. And therefore, when you pass a retrenchment order under 25F, you have to fulfill three conditions
yes,
for
Lordship,
passing
but
the retrenchment order.
in the retrenchment order, only condition was that since you have not opted for the improved voluntary retirement scheme, therefore you have to go. Simply this one, Lordship.
That's
It
fine.
is not
That's
that
the notice. Notice was given.
earlier notice was given,
Notice
but
was
he
given.
since he has not Lordship admitted the condition, Lordship. Therefore, he was returned from service, Lordship. And it is order, Lordship, it is specifically said at last para, Lordship. Accordingly, in terms of the Union Cabinet terms and terms referred above, you are hereby returned from services of the corporation from 14 October 2016 and 1997 pay scale CRS would be implemented for settlement of dues on retrenchment in terms of Union Cabinet decision.
You have not annexed the Union Cabinet decision also.
Yeah.
Except you file an affidavit saying that compensation will be paid under section 25FB. So when you're going to pay compensation under section 25FB,
Yes.
automatically the whole section 25 has to be complied with. So that retrenchment order has to go.
But strictly, it is not mentioned in the retrenchment order that it is the 25 under.
Why did you file that affidavit?
The compensation part is Lordship.
Why did
Under the
you
provision,
invoke 25FB?
compensation is to be paid under provision of Lordship 25F.
You should not have filed the affidavit.
But in reply to your we have filed, Lordship.
You have filed your affidavit.
Lordship.
That affidavit is binding you now.
Yes. Yes, depending, Lordship, we are paying them the compensation.
First you pay them the compensation, then you retrench them.
As Lordship, as per 25E, it is at the time of retrenchment, not before retrenchment, Lordship. Yes, at the time of retrenchment, it was not given. But it is not before.
What do you say about 25.5B?
At the time of retrenchment, Lordship, this compensation has to be paid.
Read it properly. What does the last word say? Until.
Yes. Until the
Until A, notice. B,
Notice.
compensation.
At
C, notice
Notification in the official gazette.
notification in the official gazette.
compensation at the time of
A,
retrenchment.
B, C. So you can't pay compensation at the time of retrenchment. You have to pay compensation before retrenchment. Then notify the official gazette. After that only you can retrench them. If you have done that, fine. Nothing survives for the petitioners. But today you are on the wrong footing.
At the time of retrenchment, Lordship, the workman has been paid at the time of retrenchment, not before retrenchment.
They have been paid.
Not paid, Lordship. We have not paid, Lordship. We are, as per my affidavit, we are paying whatever they are entitled to, we are paying them.
We'll continue at 2. You think about it.
Lordship.
Otherwise, we have to dispose this matter. There's no point in keeping pending.
Lordship, 2016 method.
I'm sorry, may I have a prayer, Lordship? Item number 4 and 5, Lordship. In this matter, my learned colleague is also sitting, Lordship. Advocate General is appearing in this matter, Lordship. I'm very sorry, Lordship. I apologize.
Item?
4 and 5, Lordship. Next item.
Yes. What do you want?
Lordship, I'm praying for adjournment.
Yeah, but
Only 11 hour, my lord, we are jobless, my lord. Lordship, can it be fixed on Thursday or
Tuesday, my lord.
Two cases are here, Lordship. In the other case, I have already informed the petitioner, but
I was sitting right from morning, my lord, and I have seen him, my lord, several times. I was not informed, I was sitting there. Anyway, my lord, lordship picks the
he will
matter,
not
my lord.
agree, Lordship. That is why. I
But
said-
Mr. Jai Babuya, learning counsel for the petitioner. In WBC 5090 of 2021. On request made on behalf of Mr. On request made on behalf of the Learned Advocate General Assam.
GMC.
When do you want?
On 7th, my lord, it is a Tuesday.
Second.
7th is a holiday, I think.
Oh, 7th is the holiday. Can it be on 14, my lord? 14 is the Tuesday.
14th.
As the last chance, my lord. আগত কিয় নকলা
আপুনি নাজানে।
এই মই ইয়াতে আছিলো মোক ক'লে কি মই নামানো নেকি কোৱাচোন গোটেই দিনটো বহাই থলা এতিয়াহে হাত
I'm sorry.
কাৰ পালা কিয় মইতো তাতেই বহি আছো
ক'লে
Another date on 2nd of May, Lordship.
Item?
28. We have some urgency in this case also.
Yeah, because I'm not constitution.
2nd of May.
Second will be difficult. We'll have it on 9th. 7th is a holiday, so 9th.
It's. Lordship. Obliged.
Maybe I think we can close the matter.
Lordship. As per my instruction, Lordship, now I have all they will pay the compensation, Lordship, due to pendency of this, the proceeding. They have-
No, I'm not dictating the judgment now.
Yes, yes.
I'll dictate in my chamber, but today and tomorrow I'm busy, very busy. So you'll get the judgment either on Monday or Tuesday. I'm making it very clear.
Yes.
Number two,
Okay, one submission matter. The interest order has been issued by the CIWC
Yes, as per the cabinet decision.
as per the cabinet decision. And there is a CIWC is a her condition is very pathetic. That's why, my lord. And my lord, this
Ultimately,
my lord, order, this my lord, interest order has not been passed, my lord, in compliance of section 25F. That is clear.
affidavit,
We are not issue.
affidavit says something else.
That is the central government. Central government has not issued the return order. Return order has been issued by the CIWC.
Lordship, affidavit
That
was,
you issued a retrenchment order on the basis of union cabinet decision.
In a cabinet decision, madam.
Union cabinet is what? The central government.
25F,
Yes.
F, madam.
Central government is the Union of India.
yes, yes.
yes,
That, my lord, but as per the cabinet decision, my lord, I have.
That we have seen in your retrenchment order is on the basis of cabinet decision.
Online cabinet decision, not my lord 25F.
So the union cabinet decision,
Union
union
cabinet
cabinet
decision,
decision is the government of
My lord,
India.
my lord, on the just only basis of the affidavit filed by central government, my lord, they cannot claim my lord compensation under section 25F. But
So
because
that
my
you-
lord,
that-
return order
that
has
can
not
be
been
his-
issued
that can
on the
be his
basis of
submission.
25F, my lord.
That can be his
That,
submission,
that
but
has to be
ultimately,
clarified by the central government, my lord.
Lordship,
Under what, one compelling circumstances, my lord, this evidence has been filed.
it was filed,
Because my return order has not been issued at any point of time under section 25F, my lord.
as per the order of the Honorable Court, Lordship, on 19/5.
My lord, this affidavit, my lord,
You
how
have-
my lord, this
you have
affidavit has been filed by the central government,
You have
has to
missed
be clarified. my lord.
A Khanikar, no?
Economic. But the central government has no authority to, my lord, clarify my retrenchment order, my lord.
Issued by the CIWC.
CIWC. This retrenchment order has been passed, my lord, after a repeated notice, my lord, issued to the petitioners, my lord. That either you accept the IVRS or you should go on. Not 25F. We have offered, my lord, on so many occasions to, my lord, offer them to, my lord, accept IVRS scheme. Formerly it was VRS, my lord, subsequently IVRS. Out of my lord, 272 employees, my lord, 267 employees have accepted by IVRS. Only 5 employees have not accepted, my lord.
so your lordship,
But this-
ultimately, I
this
think,
affidavit,
lord,
my lord,
this will have to be decided in the light of the law laid down.
But this, the affidavit filed by the central government, that should be clarified by the central government.
Lordship,
Because now we are not issued.
So she's clarifying it.
Lordship,
She has clarified it that you are going to pay
But if central government will not-
retrenchment compensation.
If central government will not take the responsibility, then
Lordship, by order dated 19/5, Lordship, two queries were made by the Honorable Court, Lordship, whether any compensation they are entitled to and whether they will be given the IBRS and sales.
So you said you cannot give them the IBRS at this stage,
We
but
can-
then you'll pay the compensation under section 25F.
But it is not
Well, but-
stated that the Lordship retrenchment order has been passed after 25. It simply said that under the provision of 25, Lordship, they can be given.
Under the provisions of 25F, you are going to pay the compensation, correct?
Only compensation part we have dealt with, Lordship, regarding retrenchment.
So if you are going to pay compensation under section 25F,
Lordship,
then it also speaks of retrenchment.
yes,
So
Lordship.
retrenchment cannot be issued prior to the compliance of the three conditions laid down in section 25F. That's all. Nothing much.
Yeah.
So you take them back. What can you claim for back wages?
My lord, usually, my lord, since this order is void ab initio, my lord, as I have submitted, they'll have, because the fact remains that they have not been gainfully employed. And therefore, they will be entitled to back wages. Now, it will be ultimately the judicious decision of this honorable court whether or not your lordship would grant them full back wages or 50% back wages. But normally, my lord, back wages is a usual consequence of reinstatement.
I'll just say respondents. I'm not specifying particular.
Yes.
Just Lordship, our affidavit is not a detailed affidavit on, Lordship, on every statement, but it is specific query of the.
And in any view of the matter, my lord,
Uh,
the responsibility ultimately will be on the respondent number 1. That is Union of India.
Anyway, we'll give you liberty.
but, what was it?
Yes.
Liberty of Lordship, filing affidavit.
Hmm?
Lordship,
No. I've not said anything about affidavit. You've already filed your affidavit.
on specific query of the Honorable Court on
Oh.
two grounds, Lordship, we have dealt with only these two questions, Lordship. Not the detailed affidavit, no, we have not filed. We have only answered these two questions. Lordship. And regarding this recruitment was under section 35 or not, recent in our affidavit.
But then issue is that you're saying that
Compensation has to pay under the provision of under some, Lordship, law, or there must be some provision,
so there has to be some provision. So you have taken you've invoked the
yes.
provision of 25F of the Industrial Disputes Act.
Because, my lord, the retrenchment also has to be in terms of some provisions of law. And that provision is section 200 of the Industrial Disputes Act.
Hmm.
So naturally, even if they have not said it earlier, my lord, it will fall back to the same situation again. So that's it. Your lordship has closed it, my lord, anytime.
Yes, though I'm allowing the petition. Retrenchment order is set aside. And then respondents are directed to reinstate you back into service with 50% back wages. Liberty is given to the respondents to retrench you if advised
Yes.
By-
By following
by-
the,
conditions laid down under 25F.
but my lord, my humble submission with your lordship would be, my lord, they are grade 4 employees. And it is apparently due to no fault of them that the order has been passed, because there was an interim order operating on them, on the respondent. So my humble submission with your lordship would be kindly to consider at least the full back wages.
the interim order is, as far as interim order is concerned, my lord, that has been closed, my lord.
No. Interim order has not been closed. Interim order was holding the
Order.
field.
My lord, they have not communicated, my lord. either my lord, petitioner side has not communicated that there is an interim order, my lord. We are not aware, my lord, that there is an interim order, my lord. We did it as them, my lord. That's why, my lord, amendment petition has been filed.
You've appeared on behalf of.
No.
this one.
On that particular, I am not.
No, no, he did not appear, but my learned friend.
No, but now you are appearing
Now I am paying, my lord, but after retrenchment, my lord, I am paying.
after retrenchment. After retrenchment, you have come to know that there is an interim order.
After retrenchment, my lord, I have come to know that there is an interim order.
You could have withdrawn that retrenchment
We
order.
have made a retrenchment, my lord.
Otherwise, this court also could have taken so much contempt
No,
notice
but
against you.
That
Yes.
question, my
That
lord,
was possible.
your lordship
Yes.
has asked that question, my lord.
But we have not taken that step.
Yes, that, my lord, your lordship has asked my that question, sir.
Mr. Kandika, I think you better keep quiet. Otherwise, you may initiate so much contempt against.
Well, my submission, my lord, that this retest order has not been issued under section 25, that may be recorded.
That you have recorded.
Deep level.
Obliged, Lord.
That is backwards lordship since 2016, they are not exotic lordship. Backwards for lordship.
You've done the mistake.
Lordship.
It's your mistake. You have to bear.
And secondly, lordship, the defect in complying the section 25F lordship does not automatically entitle the petitioners to reinstatement lordship. I have
The law is settled.
lordship.
Law is settled. Once retrenchment order goes, you have to take them back by giving them full back wages.
Yes.
But then this court is considering 50%. Let me think about it, but
Yes.
then as of now,
Yes,
I'm
yes.
thinking of 50%.
Yes, yes.
Lordship.
Obliged, Lordship.
I think that's all.
Yeah, that's.
Okay, disposed.
I have provided some document that closer of that.
Lordship, I may be allowed to submit some judgment lordship if I,
The other council has gone.
no.
Bring him back. Oh, he's there, he's there.
This is the document regarding closure of the seat.
Just clip it, not with a step. You have a clip. Like. Yeah, what do you want?
Lordship, if lordship permit, I will submit some order copy lordship, judgment copy lordship. So by tomorrow.
What judgment? No, what judgment you want?
On this issue lordship,
Of which issue?
on this issue lordship regarding retrenchment and lordship whether they are entitled to reinstatement or back wages or anything like this, or we have a defect in complying the 2025 is,
See, once I close the matter and you submitted the argument,
let's say since lordship has not passed out, but therefore I have some permission lordship.
if you want to produce some judgment, then I'm not passing any orders. I will keep it parted, that's all.
No lordship,
I'll keep it parted.
no lordship, it is already hard lordship, the same issue is there.
Lordship may close the matter, my lord. It's pretty old matter. Obliged.
But maybe only on Monday or Tuesday.
Yes.
You put this. Send it to my chamber.
Item 30, hearing.
Sir, I am for the respondent number 2, 3, and 4.
Maybe. This repetition has been filed challenging two orders, my lord. One is the refixation of the basic pay of the petitioner, by which his basic pay was reduced, and the order of recovery. We are challenging the order of refixation of the basic pay on the basis that no opportunity of hearing was
Yes.
that no opportunity of hearing was given to the petitioner, my lord, before issuing the order of reducing the basic pay. And the order of reduction basic pay was issued by the senior manager, my lord, which she is not authorized to pass. It is the
It's not the competent authority.
not the competent authority, my lord. And the order of recovery, my lord, on the basis that the recovery has been made, my lord, there was no misrepresentation or fraud on the part of the petitioner. It was because of wrong fixation of pay. Now, my lord is well aware that because of wrong fixation of pay, recovery cannot be made, my lord. These are the basically two grounds for challenging in the petition, my lord. If I may take your lordships now to page 20 of my writ petition. That is the first annexure.
One minute.
Ma'am.
All respondents are represented.
But I am effectively contesting the matter, but because
Oh.
he is my employee.
You are the respondents?
2, 3, and 4.
2, 3, and 4. How about 5?
Yes, my lord. 2, 3, 4, and 5. Sorry, my lord.
You can appeal.
How about 1?
No, one is the Union of India, my lord.
CGSC will appeal.
But as I get from my record, my lord, I have filed Hokaradama in respect of 2, 3, and 4. They are representing the company. Mainly the company is there, my lord. Therefore, the highest authority of the company is CMD, my lord. I am representing him also. And Union of India is represented by the landed additional solicitor. Yes.
Where's the CGC?
My lord, they have also not filed any objection, opposition also. They are not as such, my lord.
Anyway, where's the CGC? Have you informed the CGC?
Yes, my lord, I have told my on record to inform some also.
Unless all the parties are represented, I can't proceed with the hearing.
Inform them regarding the upgrade.
Yes, yes, I told the one. But can I have 1 minute?
Oh, my, she is appearing for
Hello.
respondent.
I am appearing on behalf of K. Fukan for respondent number 1.
Where's K. Fukan?
Yes, my lord.
So you're ready with the case?
No, I have not briefed.
Where's K. Fukan?
K. Fukan, my lord. She-
Where's K. Fukan?
My lord, out of session.
Out of station. When is she coming back? Wow.
But in this particular matter, my lord, it's the dispute between my lord petitioner and the.
At least the other respondent will have to be present. We'll have it on Tuesday then.
Next Tuesday.
They are coming Tuesday. 30.
Can I just? Lord, 13, my lord, I will bring difficulty, my lord.
Give a date.
My lord, would it be possible for your lordship to fix it then, 21st? 21st.
April, 21st of May.
Yes, my lord. 21st of May. We are in the month of April. Your lordship is next Tuesday is 30th. Huh? Today is
Heard Mr. P.K. Munir, learned counsel for the petitioner. Also heard Mr. A. Chakravarti,
Chakravarti.
learned counsel for the respondents, 2, 3, and 4. Stop. On request made on behalf of MS K. Fukan, learned MS K. Fukan, learned CGC. Release the matter on, when do you want? 21st?
No, 21st would be a little bit late, my lord, because he is going to retire on June, my lord.
So June, the whole month is there.
Let it be on 21st.
21st May.
But otherwise, your lordship would have heard us because ultimately it is a dispute between only.
On that day, if Fukan is not there, you inform her to make some alternative arrangements. All right.
21st.
Always.
The admission.
Sorry.
Petitioners are employee of the Simonto Sankodev Kalakshetra Society, my lord. Their services is regularized on 26, 2018, my lord. Similar,
You file your affidavit?
Lordship, thing is that on behalf of Kalakshetra also one affidavit has been filed, but Lordship, on behalf of Cultural Affairs Department, Lordship, that affidavit, pairs message is ready, Lordship, but affidavit has not been filed. Lordship, I require Lordship permission to file an affidavit on behalf of Culture because the stand is different. And secondly, Lordship, I have one preliminary objection, Lordship. In the matter, Lordship, I've seen, Lordship, Finance Department is not made a party. This matter is basically payer for Lordship, pensionary benefits. So finance is important, necessary party in the case, Lordship.
and our LICI group insurance.
That LIC scheme has been closed. After that, one meeting has been done in the place of Sankarda, the Simonto Sankarda Lordship. Then one resolution has been taken that
On
the case is under process before the government. Lordship, after that, one instruction we have received from the Cultural Affairs Department, Lordship. What this says, Lordship, as Simonto Sanko Collector is a society employs draws and salary from grants from their own funds. So except from granting the amount by them, other service matters do not come under the purview of the Cultural Affairs Department. Service matters have to be decided by the Simonto Sanko Collector Society itself. And the Cultural Affairs Department had consulted Finance Department on the matters twice. And extra order views of the department and close your it. Also, may see the instruction.
No, not required.
No, also I may be allowed to file the affidavit lawsuit based on this instruction. And he may be directed to complete Finance Department.
Mr.
N. Burua.
Learned counsel for the petitioner. Thanks for how much time you require?
14th May.
No, you require complete amendment of the file cover like that.
Grace for 2 weeks time to file an appropriate application for improvement of the Finance Department, Government of Assam as a party. Stop. But in the meantime, Mr. CKS Bara, government advocate, is also allowed to file affidavit, counter affidavit on behalf of the respondent number 3.
Yes, Lordship.
1 and 3.
1 and 3, Lordship.
1 and 3. This the matter on 14th you want.
14th May.
14th.
I am appearing on respondent number 2.
Mr.
Vijay Boro on behalf of Jete Goswami.
Mr.
Vijay Boro on behalf of Jete Goswami.
On behalf of the council, on behalf of respondents, J.K. Goswami appears for respondent number 2. 2? How about 4?
So 4 I can appear, I think.
4 you cannot appear.
Already
Yes,
filed
Marco
affidavit.
saying because lordship, this affidavit has been filed.
Filed, my lord.
Lordship,
Why respondent 4?
yes, lordship. The affidavit has been filed by the government advocate, lordship, one. Not single one. That is the reason, lordship, I am appearing. Otherwise, I would not appear for Polakapur.
Did I give a bit? Okay.
Lordship.
A,
Wait, please, your lordship. Lordship, on the last occasion, my friend has paid for some time to file their affidavit. In the midst of the hearing, one query was put to my learned friend, wherein he said that an affidavit will be filed. It's not been filed.
Nayak,
Lordship, I have already received the signed copy, lordship, but tomorrow or day after tomorrow, I'll file.
okay, heard Mr.
K. M. Mahanta.
K.N. Manda, then the counsel for the petition. Mr. P. Nayak, then the standing counsel PNRD,
Lordship.
department. Copies that will be filing after the within a period of 1 week.
I think we taken on
Yes, hello.
14th of May.
Please submit on 14th. Interim order passed in there to continue in the next week.
Obliged.
9,
My lord, before my senior starts, I just want to do one thing with your lordship. On the last occasion, my lord, I made a statement that I have received a record, my lord,
Instructions.
instructions, my lord.
Oh,
My lord, in fact, my lord, what happened, my lord? These are some not instructions even. Later on, when I checked it, my lord, the previous writ petition and the affidavits, that is what they have said by default. And the records, my lord, they write, the chief engineer writes that it was sent to one of our council. Then I have inquired, it was again sent back. So that is the position, my lord. So, my lord, without that record, there is a direction, and without that, it becomes really difficult. So that is the thing, my lord. I have talked to the engineer even, my lord.
Three
chief engineer.
times they are taking time on this claim, and
My-
they should pay some cost.
My lord,
And the lordship will allow them.
we'll
my
see.
lord, my lord. This is the first time that I am seeking time, my lord.
No, last
Yes, my
occasion also same.
No, my lord, last occasion, the matter, it reached at the end of the, my lord, it will be taken up, my lord.
Last occasion, Mr. R. Dhar, Leonard Standing Council PWD submits that he has received instructions and pressed for some time to go through it.
Exactly, no, that is what, actually, that was record, my lord. That record, when I,
Today, your lordship will not give him time and without cost
lord-
of 50,000.
We'll see. Heard Mr. B.T. Das, Leonard Senior Council, assisted by Ms. R. Dekar,
That's the debate.
Leonard Council for the petition.
From his pocket.
On request made by R. Dhar, Leonard Addition Senior, Leonard Standing Council PWD. List the matter again on, when do you want?
my lord,
No,
after
no,
10
let
days,
it-
my lord.
Yeah, date may be fixed, my
No,
lord.
that's
This
what-
matter is simply, my lord, going as per their wish, my lord. They are at a.
List on,
My senior will fix it, my lord. After
Let
10
them
days, my lord.
fix, my lord.
you
They are
fix the date,
prerogative.
you fix the
After,
date.
after 7, my lord, election, my lord.
You want it on a Tuesday,
Yes, no.
on a hearing day,
Yes, no.
9th? Is it okay?
Yes.
9, can you get your records?
My lord, 9, 10, some other hearing matters are already fixed, my lord. 9, 10, both the dates.
16th, 16th. To enable him to produce the reports.
10,
Wait, please, your lordships. Well, matter, my lord, mainly pertains to my lord non-payment of second MSCP matter. Modified annual
modified issued career progression scheme, my lord, MSCP, my lord.
Oh.
Here, my lord, the government of India, my lord, in the personal department, my lord, had issued, my lord, office memorandum, my lord, in the year 2009, my lord.
Who is that?
Where, my lord, your lordship, my lord, will find, my lord. Page 17, my lord. Yeah, my lord, had this office memorandum, my lord. The personal department, my lord, had, my lord, sanctioned some benefit, my lord, provided some benefit to the employee, my lord, who have continued, my lord, to service in for 10 years, 20 years, and 30 years, my lord. Whoever completed 10 years, my lord, he will get first MSCP, my lord.
Who is the
And-
guideline?
My lord, this is the, my lord, office memorandum, my lord, and guideline, your lordship will find page 30, 20, my lord. Page 30, my lord. Modified issued career progression scheme, my lord. There shall be 3 financial upgradation under MSCPs counted from the direct entry grade on completion of 10 years, 20 years, and 30 years service respectively. Financial upgradation under the scheme shall be admissible whenever a person has completed 10 years continuously in the same grade pay, my lord. Here, my lord, petitioners entered into service, my lord, in the year 1997, my lord. And in the year 2017, my lord, he had thereby completed 20 years of service. Thereby, my lord, he was eligible for second MSCP, my lord. Now, my lord, that benefit was not given. Accordingly, my lord, the petitioner had approached before the Honorable Court, my lord. For during the pendency of the petition, my lord, they have filed an affidavit in opposition, my lord. Thereby, they had annexed an office memorandum, my lord. First of all, my lord, kindly see, my lord, why they have rejected my claim, my lord. Kindly come to page 93, my lord, running page, my lord, of their affidavit in opposition, my lord. Running page number 93, my lord. Here, my lord, there is a list, my lord. My lord, yes, my lord. My lord, serial number, my lord, 30, my lord. This is the petitioner, my lord, Shankar Das. Shankar Das. Kindly see, my lord, the 7th column, my lord, 6th column, my lord. Date from which due for sanction of second MSCP with pay scale, my lord. Here, my lord, due for sanction of second MSCP with effect from 10/3/2017 in the pre-revised pay scale of 5,200 to 20,000. My lord, kindly note this, my lord. It is important, my lord. Public grade pay 2,800, my lord. Grade pay with, kindly see, my lord, this whole line, my lord. It is, my lord, most important, my lord. With grade pay, my lord, 2,800 within bracket, my lord, level 5 of pay matrix 29,200 to 92,300, my lord. And kindly see the next column, my lord. ACR grading list, 5 years, last 5 years, my lord. They have said that in the year 2013, my lord, my ACR was good, 14 was good, 15 good, 16 good, 17 very good, my lord.
What is there in the remarks?
Remarks, my lord, not recommended for second MSc, my lord, due to lack of benchmark grade ACR, my lord. It is not completed, my lord, in my page also, my lord, but it is there, my lord.
Where's the
You did not-
original copy?
My lord, it is, I have served with this copy, my lord, it is not completed, but not recommended, my lord, it is shown, my lord.
Who has
Thank you.
issued
Complete.
this?
My lord,
Sharma, you have a full copy of this?
No, the same copy is there, Lordship.
How can we have? No, we don't know.
my
what
lord, only, my lord, it seems, my lord, not recommended, my lord.
We are not recommended for.
For, my lord, cannot, my lord, with evidence due to back.
Lordship,
Investment.
take up page number 97. 97 part 2 column is there is one part 2 that 04 serial number is there. There Lordship will find the
Yes, there, my lord, like this, my lord.
serial number 4. The petition.
below the prescribed benchmark, my lord.
Yes.
Now, my lord, kindly see the what is the benchmark required, my lord. Kindly come, my lord. Kindly come to, my lord. Their office memorandum, my lord, issued in their 2019, my lord.
1 minute. So what is the benchmark prescribed?
My lord, they are said, my lord, they are saying that all the last 5 years should be very good. 13, 14, 15, 16 should be good. 17, in fact, petition is very good. But in the year 2013, 14, 15, and 16, my lord, 4 years, my lord, he was benchmark was good. This year was good, my lord. Now they are saying that no, he should be very good in all the 5 years. My lord, however, the notification says, my lord, he need not be very good in the last 4 years. Only 17 from 17 very good. Other good is will be there, my lord. I am coming to the notification, my lord. Kindly come to page 105, my lord. This is the OM, my lord, part of the OM, my lord, OM dated 22nd of October 2019, my lord. Page 105, my lord.
Yes.
My lord, before the 100, I am coming to 104 last, 104 also, my lord. Paragraph 17, my lord. For the 104, my lord. For the grant of financial upgradation under the MSCP scheme, the prescribed benchmark shall be very good for all levels. This shall be effective for upgradation under MSCP falling due on or after 15/7/2016, my lord. And the revised benchmark shall be applicable for the APRs for the year 2016 and 17 and subsequent year. My lord, very good.
Where's the revised benchmark?
My lord, Rashid got the 17.1, my lord. What?
17 I've seen.
Yes, my lord.
It says the benchmark will be very good
Very good.
for all levels,
Yes, my lord.
falling due on or after
After,
25
yes.
cents.
Yes,
But for 2016-17,
yes. The
ah,
revised benchmark shall be applicable for APRs for the year 2016 and 17. That
where's
is
the
very good.
where's the revised benchmark?
Now, my lord, kindly see, come to the next.
Where's the revised benchmark? I'm asking you one question. Answer that question.
The revised benchmark, they have said that it should be very good. They are saying, my lord, this is the office memorandum.
Sharma, where's the
Annex, page 73, Lordship. In fact, page 74. Clause 4, 5, 6, 7,
1 minute page?
74.
My lord, now this notification pertains to, my lord, 27 September 2016, my lord.
Hmm.
That is what I am saying, my lord. After 16, my lord, that benchmark will be very good. I am not objecting on that. Before that, it was good. And that was, my lord, explained, my lord, the notification of 2019, my lord. They have annexed there, herein, my lord.
Where's the notification?
100, kindly come to, my lord, page number 104, my lord. 105, my lord. That was earlier, my lord. 105, my lord. Here, my lord.
Lordship, before going to that, Lordship may kindly come to their prayer, Lordship. What is actually they are praying in this writ petition, Lordship? Lordship may come to page 15, Lordship. And we have also objected on the ground of delay because they are challenging an APIR of 2016 and this writ petition is of 2022, Lordship. Their prayer is that a writ of mandamus shall not be issued to the commandant so and so to grant the benefit of second MSCP to the petitioner by reviewing the grading of the petitioner from good to very good in the APIR of the petitioner. Now, Lordship, how could direct them to review, Lordship. That review was done on the basis of his performance.
Even my lord, if review is not done, even that my lord, my good will work, my lord here.
Okay, okay, we'll see.
Yes, my lord. Kindly come like 105, my lord. Page number 105, my lord. Paragraph 72, my lord. While accessing the
One
suitability
minute,
of an
one
employee,
minute.
105, my lord. Page number
Yes.
72, my lord. While accessing the suitability of an employee for grant of MSCP, the departmental screening committee shall assess the affairs in the reckoning period, my lord. The benchmark for the APR for the year 2016-17 and thereafter shall be very good. The benchmark for the year 2015-16 and earlier years shall be continued as per the MSCP guideline issued by the Department of Personnel and Training, my lord, dated 19/5/2009, which reads, my lord, that is quoted, my lord. The financial upgradation would be non-functional basis subject to fitness in the hierarchy of the grade pay within pay band 1. Thereafter, for upgradation under the MSCPs, the benchmark of good would be applicable till the grade pay of rupees 6,600. In the pay band 3, the benchmark will be very good for financial upgradation to the grade pay of rupees 7,600 and above. And there is an example is also there, my lord. And why I am referring this, my lord, because earlier, my lord, that list, my lord, which I have already, my lord, showed
Let-
you
let us
lost
see-
him, my lord.
Let us see that list.
Okay. Page 93, my lord. Here you lost will see, my lord. What is my grade pay, my lord? Grade pay only 2,800, my lord. And level 5. Well, very good, not applicable in this grade pay, my lord. That will applicable after that, my lord.
So what is this notification?
Now kindly see the example, my lord. They have quoted, my lord, the notification, my lord. 105, my lord. Here, my lord, for example, if a particular MSCP falls due on or after 25/7/2016, the following benchmark for APRs are applicable. APR for the year 2013-14 and earlier years, benchmark grading for MSCP for level 11 and below.
Your level?
5.
Your level 5.
Yes, my lord. As I have earlier shown, my lord. This is good. There are 14-15 good, 15-16 good, 16-17 very good, 17-18 very good.
Now let us see your list.
Kindly see the list, my lord. That list, my lord, page 93, my lord. Here, my lord. Level 5 of grade metrics. My lord, here, my lord, it is clearly shown, my lord. Due for sanction of second MSCP with effect from 10/3/2017 in the pre-revised pay scale 5,200 to 20,000. Grade pay 2,800, madam.
Your level 5.
Yes, madam. This is already indicated, madam.
Where?
That's the close, madam. What I showed the table, madam. Page 93, madam.
Hmm.
Here, madam. Due for sanction of second MSCP with effect from 10/3/2017 in the pre-revised pay scale 5,200 to 20,200. Oblique, sorry, it is 20,200. Grade pay 2,800. Within bracket level 5 of pay matrix so and so. So my level is 5 and grade pay is 2,800. Now this notification, my lord, clearly covers my case, my lord. The OM dated 19 OM, my lord, page 105. It clearly covers my case, my lord. Kindly see here, my lord. benchmark grading for MCP for level 11 and below. My lord, 14, my benchmark was good, 15 my good, 16 good, 17 my lord is very good. So it is squarely covered. Now there my lord probably my lord misconceiving the my lord context of this my lord office memorandum, my lord, they have rejected my lord. Benchmark very good is applicable only after level 12 my lord. Level 12 and above.
Yes.
My lord, in the ACR grading also my lord, 2013 that page 93 my lord, which I have earlier indicated my lord. Here my lord ACR grading my lord, can you see 2013 guess grading was good, 2014 good as covered, 2015 good covered, 16 good covered, 17 my lord very good, it is also covered my lord. So my lord, I am definitely eligible for second MSCP benefit my lord. They cannot deny this my lord. This is my case my lord. Even if lordship goes to the 2009 notification, that also covers my lord, because I have already completed 20 years of service, and 2019 notification, it is equally covers my benchmark also my lord.
Where's the 2009 notification?
Yes my lord.
No, where's that notification?
It is here also my lord, 2009. My lord, in my repeations also there my lord. Page 17 my lord.
Which?
17 my lord. The office memorandum my lord, page 20 will be relevant portion my lord.
Which?
17 my lord. Because second MSCP will be applicable to those employees my lord, who have already completed 20 years of service. My lord, by the year 2017, I have already completed 20 years of service. My lord. That also enables me for second MSCP. And 2019 notification, my lord, on the basis of which they have rejected, my lord, that also covers my case, my lord. So they cannot deny me, my lord.
Yes.
My lord, paragraph 17, my lord, that when of 2019, my lord, squarely covers my case, my lord.
Paragraph?
My lord, that paragraph 17, my lord, 17 2, my lord, which I have, my lord, read down now. Just 105, my lord. That equally covers my lord, and I have already annexed the page 93 my lord, which my grading also there my lord. It was reflected in the grading my lord.
Mainly, my lord, page 105 will equally covers. 105 page number, my lord, that will equally cover my case. Paragraph 17(2).
Yes, Sharma.
First of Lordship, I have already stated that Lordship, what is his prayer in this writ petition, and also I have objected to the delay because they are challenging PIR of 2016 Lordship. Their main prayer is that.
Okay, where's your rejection order?
My lord, they
Yes,
have
Lord.
not rejected, my lord. They are not given the benefit, my lord. Because, my lord, I have already shown the list, my lord. They have prepared the list, my lord, and they recommend, my lord, that who the candidates are eligible for second MSCP, who are not, my lord. And my name was wrong, my lord, illegally, my lord, rejected, my lord, because they have misconceived the notification of 2019, my lord.
So this annexure I, correct?
It should be annexure. Yes, my lord. Annexure I made.
I have stated Lordship that from Lordship may kindly come to page 58. So here we have stated that from benchmark for performance appraisal for promotion and financial upgradation under MSCP to be enhanced from good to very good. As he has shown that pay band Lordship from 2016 onwards Lordship, there is no differences. From 2016 onwards, it is very good for all categories Lordship, as it is their Lordship. And he is supposed to get his MSCP, second MSCP from 15/3/2017. No? 15, and these changes came from 25th July 2016. And our notification is very much specific, Lordship, that already I have shown, Lordship. May kindly come to page number 74 again, Lordship. Clause 6. These changes will come into effect from 25th July 2016. That is from the date of resolution notified by Department of Expenditure, Ministry of Finance regarding acceptance of the recommendation of the 7 CPC. The comprehensive MSCP scheme on acceptance of 7 Central Pay Commission recommendation will be issued separately. So those persons who were supposed to get the MSCP after 25/7/2016, for them, the MSCP, ACR criteria is very good for 2016-17 and thereafter, Lordship. For 2016-17, which is for 2016, his benchmark criteria is good, Lordship, which should have been very good, Lordship. For 2017, his criteria, he had very good, Lordship, but for 2016, he is his overall rating is only good, Lordship. And this next page also is very much specific about that, Lordship. May kindly see page 75, clause 3, serial number 3, page 75. I'm reading from first Lodge 2. The board has been receiving a number of references from various field formations of CBEC association and individual on the subject mentioned above, seeking clarification whether the revised benchmark of very good with effect from 25/7/16 may be applied to ACR APR of 2015-16 and period prior to that, and whether the officer should be given opportunity to represent against the good grading of past ACR or APAR. The matter has been examined in consultation with DOPT, and DOPT has opined that there is no question of allowing second opportunity of representation against the APR, which are post 2009, as these are already disclosed to the employees in APR process. DOPT by OM dated 28/9/16 has implemented the recommendation of 7 CPC. So 28/9/16 has implemented the recommendation of 7 CPC accepted by the government for enhancing the benchmark for grant of MSCP to very good. These instructions are applicable with effect from 25/7/2016. The date of issue of government resolution by expenditure. Therefore, in cases where the MSCP falls due on or after 25/7/16, the price benchmark of very good is to be followed. In other words, the overall grading of the APR region reckonable for grant of MSCP should be at least very good. So, Lordship, those who have after 25/7/2016, that should be very good. If Lordship sees the serial list also, Lordship, that annexure I, Lordship will see those persons who were recommended are either very good in all 5 years or outstanding and very good. His cases was also considered, Lordship, annexure J, but his case could not be, he could not be get the benefit, Lordship. That page 97 I have shown, not recommended for sanction of second MSCP with effect from 10/3/17, as his overall ACR grading during last 5 years is below prescribed benchmark. As he is saying that it should be from 2000, then also, Lordship, from 25/7/2016, he should be very good, Lordship. But for 2016 also, his ACR criteria is good. For 2016, at least he should have been very good. If this page number 105, Lordship. 2016-17, very good. But for 2016, his grading is good only, Lordship.
No, 2016-17.
Because this is shown as two years, but in our that 1 year said that 2014-15, this is for 15. The 2014-15 period, but that should be for 14. This 15-16 is for 15, and 16-17 for 16, and 17-18 for 17. It should be read like that, Lordship.
No, 2013-14 is what? 14.
2013-14 is 13. Because we have stated, Lordship, that his in my page 62, we have stated in clause M that against the APR grading good for the year 2016, dated 14/16 to 31/12/2016.
One page.
62. That against APR grading good for the year 2016, dated 14/16 to 31/12/2016. So from 2025/7/16, it should be very good, Lordship. But for this period, 14/16 to 31/12/16, which is for 2016, his grading is good only. This new revision came from 25/7/16. That will be applicable up to 31/12/16, but for that year, his grading is good only. Others are in all persons who were selected for MSCP benefit, they are either very good in all years or outstanding, Lordship. 4 persons were not granted that benefit because they were also of the same category like the petitioner. This page 97, some were not allowed for first MSCP because grading, their last 5 years grading is below prescribed benchmark. Here his benchmark should be good in 3 and very good in 2 years, Lordship. For 2016, at least he should have been graded very good. Then he could have a case, Lordship. But for 2016-17, which would be the year 2016, his grading is good only. And these recommendations were applicable from 25/7/16. For this, it's not that his case was not considered. His case was duly considered, but due to lacking, his could not get that benefit, Lordship. And that was
My lord,
2016 is good only.
my lord,
It should be very
that
good.
notification, my lord, which was issued, my lord, 20, that benchmark, my lord, the very good, which was made effective with effect from 26/7/2016, my lord. It was made effective, my lord, with effect from 26/7/2016, my lord.
Hmm.
But ultimately, that getting will be counted, my lord, for the year 2017, my lord. And that
No. It is effective from 25/7/2016.
16, my lord.
Then
What ultimately, my lord, that getting will count for the year 2017, my lord. My lord, 1 year, my lord, 1 year start from January to December, my lord.
read this. Read this page 75.
the matter has been, my lord, examined in consultation with the DOPT. DOPT had opined that there is no question of allowing second opportunity of representation against the APR which are post 2009, as these are already disclosed to the employees in APR process. DOPT filed OM dated 28/9/2016 has implemented the recommendation. My lord, kindly see the OM dated, my lord. 28/9/2016, my lord.
Carry on reading.
Has implemented the recommendation of 7th CPC accepted by the government for enhancing the benchmark for grant of MSCP in is very good. These instructions are applicable with effect from 25/7/2016. The date of issue of government resolution by DO expenditures. Therefore, the cases where the MSCP falls due on after 15/7/2016. Thus, revised benchmark of very good is to be followed. In other words, the overall grading of the APRs recognizable for the grant of MSCP should be at least very good. My lord, this the notification 2017, my lord. And it was, my lord, overtaken by the 2019 notification, my lord. That which I have, my lord, already read, my lord, 105, my lord.
So 105 also prescribes 2016-17, very good.
Yes, my lord. 2016-17, that is 17, my lord. They
No,
are
no,
saying, my
no.
lord, kindly see, my lord.
According to them, 2013-14 is 13. And 14-15 is 14. 15-16, 15. 2016-17, 16. So 2016 you got good.
My lord, in the ACR grading, my lord, they did not show, my lord, just they have shown that 2013 good, 2014 good. My lord, 2013 from which period to which period it was counted, that is not shown, my lord. Now they are, my lord, interpreting in other words, my lord. Because in the ACR, my lord, they did not show that that ACR for the year 2013 is counted from that period to that period, my lord. And that notification was issued 2016, my lord.
Then we'll have to see the ACR. How from which period he was graded.
Yes, my lord.
Graded. You produced the ACR for the period 2015-16. Or you produced the ACR of the period 2016. The 2016 ACR.
Yes.
Heard, Mr.
Yes, okay.
That's how MSB Sharma and CGC shall produce the ACR of the petitioner for the year 2016. When can you produce it? You'll recall how many weeks?
3 weeks at least. Let me try.
Is the matter after 3 weeks?
No. May I pray for a date, my lord? After 4 weeks also, my lord, date will what, my lord? Only date, my lord.
Okay. 28 April. Is it okay?
May.
Oh, May 28.
Well. Oblige.
11, 11,
Also, this matter pertains to a person petitioner hearing who is pleadings are complete, Lordship. Both the parties have filed their pleadings. The facts of the case are such.
Oh, I press on the other side. Last time it was one Lakar.
Yes, this he has gone out to the washroom. I just met him. I may start with the facts. He will join. Petitioner, after having been served as Havildar, and he has been now been recruited in the Defense Service Corps in the Territorial Army. The facts of the case is such that while he was working in duty, he was asked to lift some tin sheets while on duty, and while doing so, he
injured his finger, and after giving first aid, his finger turned gangrenous and it has been operated and it's been cut down. And that is how the order has been passed, the impugn order, which your lordship will find. Type copy is at page 28, annexure 7. I have been discharged. Page 28, annexure 7. My contention, your lordship, in this case, is on the rules which has been applied. Yes, your lordship. Page 28, annexure 7. This is a type copy, lordship. Lordship will see discharge, transfer, retransfer to pension, yes, on completion of terms of engagement. Primarily, I contend, your lordship will see serial number 2, under which the rules under which I have been discharged. It says, if I may read it slowly, your lordship, serial number 2. Personnel mentioned to Apex to this letter will be discharged, transferred, retransferred to pension establishment on completion of terms of engagement under Rule 13.3, Item 1, within bracket I, A for ZCO. That applies for ZCO. I'm not ZCO. I'm on the other one. Rule 13.3, Item 3.1 for OR. OR here stands for other rank, your lordship, of Army Rules 1954, being not meeting eligibility criteria for further extension of service. Now, primarily, lordship will take up the Army Act. Here I say, lordship, Rule 13, Section 13. Rule 13, if I may read it slowly, lordship. Here, your lordship, the provision which has been applied to discharge me.
Rule 13.3.
Yes, your lordship. 13.3.
Rule
They-
or section?
Lordship, here it is a rule only.
Your section does not have 13.3.
It's authorities empowered to authorize discharge. Chapter 3, lordship. Army Rules 1954.
Yes.
Yes, your lordship. Lordship, 13 starts with authorities empowered to authorize discharge. So what they have, the rule which they have used to discharge me is Rule 13.3.1 on fulfilling the conditions of his enrollment or having reached the stage at which discharge may be enforced. That is a wrong provision of law to my humble.
No, 1 minute.
Yes, your lordship.
Rule 13.3.
Yes, your lordship. Rule 13.3.1.
Item 3.1. What is item 3.1?
Yes, lordship. That is the thing.
Item 3.1.
Yes, on fulfilling, probably it starts on full one. Item 3.1. Persons enrolled under the Act who have been attested. It starts.
No, Rule 13.3 is there,
Yes, your lordship.
but Rule 13.3, item 3. Where's item 3?
In my book, lordship, there is a table made out.
Yeah, there's a table here.
Yes, lordship, I will
But
see.
there's no item here.
First, it starts with junior commission officer, first table.
Yes.
Then it comes, lordship will turn the page, warrant officer.
Uh,
Then subsequently, after that, persons enrolled under the Act.
Hmm.
That is 13.3. Then subsequently again, lordship will turn the page. We'll see item 3 is there. Having been found medically unfit. Having been found medically unfit for further service. 3.
yes.
Yes, your lordship. I'm aggrieved by that. This rule ought to have been used while discharging me. They have used prior to that. On fulfilling the conditions of his enrollment or having reached the stage at which discharge may be enforced.
that was a rule, to my humble understanding, the wrong rule applied in my case. That is first part of my submission, Your Lordship. The rule which ought to have been applied is Rule 3, having been found medically unfit for further service.
So it should be item 3 within bracket 3,
Yes, Your Lordship.
Roman 3.
Yes, Your Lordship. That is what ought to have been used. But the discharge, the impugn Annexure 7, they give a reference of the Rule 13.3, item 3.1. That could have been done only when fulfilling the condition of service. Here, the condition of service was not fulfilled. I had 5 more years of service left. And while I was on duty, I met with an accident whereby my finger was cut. And thereby, this rule, which says, having been found medically unfit for further service, and it has to be, Lordship will see on the next table, commanding officer. And it has to be done to be carried out only on the recommendation of an invalidating board. This is how the process has to be done. In my case, nothing as such has been done. Only the discharge has been done under a wrong rule, and I've been removed from service, while 5 more years of service are still left out. Now, Lordship, coming next.
Okay, 1 minute.
Yes, Your Lordship. That is the prime illegality which has been done.
Who discharged you?
Lordship,
Who discharged you?
my the discharge order was given. The senior record officer.
So where's your name in this order?
This has been given to me, Lordship.
Hmm?
This was given to me.
How do you know that by this order you're discharged?
They while filing the reply, they have also referred to this in their reply.
Where's the appendix?
Yes, Your Lord. And my case is also this, that they have not given me all the documents. There is also one. These are the documents which I had in my possession, and from I could make out that I have been removed illegally. Now, Lordship, for a moment, if I can say the injury part, how the injuries happen.
Do you have a copy of this appendix? Huh? You have a copy
I have annexed a complete copy. That is
in your affidavit
that is page 49.
of your affidavit?
Yes, Your Lord.
His name is dear Lordship. Amount of order.
It starts from page 48.
One. Page?
Page 48. The operative portion is 49.
Yes, Your Lord. Annexure R3, Lordship.
Yes. What is the petition's name?
One Lordship. Amount of
One.
order.
Page 49, serial number 1. Their Lordship, they have specified the medical category while removing me from service.
Hmm.
and also the date of discharge.
Date of discharge is
13/9/2019.
Just adjacent to medical category.
and what is your superannuation?
Lens Naik.
Okay, proceed.
Yes. Lordship, now coming to the facts again. Annexure 2, Lordship.
Annexure?
Annexure 2, page 17 of my writ petition.
Was this matter heard earlier?
No, Your Lordship.
How many judgments are here?
Probably these are from
Okay. Annexure 2.
and annexure
So
2.
your first ground is
Ron,
Rule 13(3), item 3(1),
yes,
wrongly applied.
yes,
Huh?
yes, Your Lordship.
And it should have been carried out after being recommended by an
Yes, Lordship.
invalidating court.
If court finds out that thing, the whole thing, my whole process, then I have to be again taken back into service and a new process has to. That is
Yes.
one. Then coming to the facts, Your Lordship. Now,
Annexure?
Annexure 2, page 17.
Yes.
How the injury has happened. This is the medical record. And this is a discharge slip. If your Lordship will see in the first part, 151 base hospital, discharge slip. Patient name is Hemanto Bodle, that is a petitioner. As adjacent to it, Lordship will see serial number 8. My rank is given Lens Naik. That is the rank I was holding on the time I was injured. And Lordship coming below, the injury report is initiated on 13/11/18. Injury happened on 13/11/18. The brief case summary is given, Lordship. If I may read it slowly, Your Lordship. 49-year-old serving soldier sustained a crush injury, right middle finger, on 31st October 2018 at unit location at around 11:40 hours. His finger was caught between CGI sheets while working. Circumferential laceration while working. Full stop. Circumferential laceration at the level of distal interphalangeal joint of right middle finger. No capillary in nail bed. The patient underwent primary closure on 31st October 18. The distal segment turned gangrenous. The next day, he underwent amputation at the level of middle flanks on 3rd November 18, along with wound closure. So this is a brief summary of my injury report. I was injured, then operated, then the fingers turned gangrenous and it has to be amputated. Now, Lordship, I was given the duty of the rifleman. I was doing the duty of a rifleman. So after this injury, they found me to be incapable. And they put it to me a category of low category in medical category. And they say they have discharged me using a wrong rule, which ought not to have applied in my case. The right, as your Lordship has seen, the rule which ought to be applied was the rule 3.3, which says the invaliding board after taking into account everything, because I am entitled to this pensionary benefits also because of the injury. Now, Lordship, this is the injury, the facts of the case where the injury has been brief summary of the injury has been given. Now, your Lordship, if your Lordship takes the Annexus 6, page 23, there in one of the document, there is specified the percentage of disability which after the injury. If I may take your Lordship to the original copy, which is 26.
Page
26. This is the not so legible copy, but it is original, it has been given to me. There, Lordship will see serial number 17. They say, is the disability attributable to service? Yes or no? If so, please explain.
Lordship has found it. And below that, if 18, it says, if not so directly attributable to service, was it aggravated by service? Yes or no? If so, please explain. Then Lordship, there's a finding, which is not so, in the type copy, I've made it legible. Here it says, no opinion can be given. No opinion can be given in the absence of injury report and court of inquiry injury report initiated at, so ultimately the procedure which was ought to have been followed was not followed, and the inquiry report and court of inquiry injury report was not initiated. And your Lordship, below that,
No, it says court of inquiry injury report initiated.
in the absence of, no opinion can be given in the absence of injury report and court of inquiry injury report initiated. It says,
The court of inquiry injury report
this too was not initiated.
was initiated.
Court of inquiry injury report.
Is it not or initiated? You have a clear copy?
No, your Lordship.
You have.
Records are necessary for this case.
First, I have PI books first. I have collected it.
Because down below, they have given a percentage also, 97%. That is more important, Lordship. What now they have taken a stand in their reply, saying that my injury falls below 20%. That is their case now. Practically, their case is that I am not eligible for anything because my percentage of injury.
No, no, no.
This is part of this. If this can be produced also. Probably this is not given. No. That is not given.
That copy is not available. But the other document, this is the other document, Lordship, wherein his.
No, no, no. This copy, page
copy-
26.
That legible copy is not available.
You get a copy.
Yes, your Lordship. This is very important, Lordship.
Give him that.
But here also, Lordship, this is also this has also been furnished by the department, and here also the his shift. The main thing is what percentage of his disability, Lordship, that is 9 to 10%. That is mentioned, Lordship.
97.
9 to 10%, Lordship.
That is there now they are disputing. They admittedly in this document, Lordship, it says 97.
Right.
That is why the original record is negative.
Cutting a finger, Lordship, 97% disability will not come, Lordship. Cutting a finger of
It will, Lordship, because I
97%
was a
will not
rifleman,
come,
Lordship. My whole duty was to take the rifle and be at a sentry point.
Now, what document? This is a medical court proceedings.
Yes, your Lordship. So they are the authority. They are the custodian of this. This document, Lordship.
I'll just say you produce the records.
Lordship.
Okay.
Yes, sir.
What, Mr.
K. Mahanta.
K?
K. M. Mahanta.
K. Manda, Leonard Counsel for the petition. Mr.
PS Locker.
Lakar. P.S. Lakar, Leonard CGC shall produce the records in original. List down when do you want?
16. Mate law. 9th. 9th. Lordship.
On 14, Lordship.
Can you produce it?
On
Mine.
14.
Okay.
Oblige, your Lordship.
14.
Can this matter be kept parted?
Not super.
13.
May please, your Lordship. On the last occasion, I have whatever the written argument as well as the judgments which I will be relying on, my lord.
Perhaps my lord, it will be on the record.
Have you got a copy?
My lord, this is- But this office memorandum, my lord, talks about the preparation of the confidential reports and time schedule therein, my lord.
Yes.
My lord, the issue here pertains to my lord, non-communication of the adverse remarks. My lord, after the last hearing, my lord, we have again verified the records, my lord.
Before my
And,
I'll make it clear. Non-communication of the adverse ACRs, not remarks. Not the remarks.
my lord, certain facts which we came to know, my lord, that was. Lord, these communications, my lord, were not annexed by the petitioners perhaps, my lord. In the year 2007 itself, my lord, the two periods, my lord, which is under issue, that is ACR for the period 14 May 2005 to 19 January 2006, my lord. That was the petitioner has filed a representation against it. That was considered and rejected. And my lord, next page is the communication of the adverse remarks relating to the other period, that is 1st April 06 to 31 March 07. So these are the two periods which is under issue, my lord, which the petitioner is alleging that the adverse remarks were not communicated to him. Whereas, my lord, from the records, it is revealed that the adverse remarks were communicated and the representation was rejected. And
The adverse remarks for the period 14th May 2005
yes,
to 9th January 2006, he made a representation.
yes,
Which was later on rejected by the memorandum dated 22nd March 2007.
itself, yes,
Then for the period 1st April 2006
my lord.
to March 2007.
Communication was made to him regarding the adverse remark, because my lord, earlier adverse remarks were to be communicated and that was duly communicated. Now, what happened in 2010, my lord, 2010, when the notification came, my lord, after that, my lord, the below benchmark gradings also was directed to be, my lord, communicated by the office memorandum, my lord. That is at page, my lord, 51
Of the writ petition.
of the writ petition.
Hmm.
My lord, this OM came on, my lord, dated 13/4/2010. The subject reads, my lord, that below benchmark gradings in ACRs prior to the reporting period 2008-9 and objective consideration of representation by the competent authority against remarks in APAR for upgradation of the final grading. Now, my lord, pursuant to this notification, my lord, at page 67, my lord, the authorities have again communicated, my lord, for the same period. Page 67, my lord. That was the notification, my lord. In that notification, there was a instruction issued to all the department that the below benchmark grading should be communicated.
Oh. Okay, Saikya,
My lord,
proceed. This may take some time.
it will take some time. My lord, the ACRs, my lord, were related back to my lord. As you lordship has seen.
Have you got a copy of this, the documents that?
I have 22/3/2007. I have, yes. Well, these are the remarks only given by the IO, not the entire remarks. All the three officers, my lord. Initiating officer, reporting officer, and the accepting officer. Three officers are involved in the, my lord, preparing an ACR. Only in respect of the IO, they have forwarded the remarks only. And they had to, my lord, give entire ACR. My case is that they have to, my lord, communicate at the entire ACR to the petitioner immediately after the preparation of the ACR in terms of the DOPT guidelines of 85. And my lord, Apex Court, my lord, as well as your lordship has held in the case of Dipsan Nag, that my lord, non-communication of adverse ACR is violation of Article 14. And therefore, my lord, the authorities were directed to consider his promotion without considering those adverse ACRs which were not communicated in time. It was communicated, I admit that, but that is after holding the DPC. The ACR was communicated to the petitioner. I received it on 8/7/2010, and the DPC was held on 29/6/2010. 22 days.
But you made your representation on 8th of September 2006.
Yes, that is against the entry given by the IO. Adverse entry given by the IO, not the entire.
IO is what?
That is initiating officer.
Initiating officer.
My lord. There are three officers, my lord. In preparing an ACR, my lord, three officers are involved: initiating officer, reviewing officer, and the accepting officer. The reviewing officer as well as the accepting officer may not agree with the findings of the initiating officer also. They can well upgrade the ACR also. But those remarks were never communicated to the petition.
Of the reviewing officer and the accepting officer.
What is adverse is only communicated, madam. The IO has passed the adverse remarks. Only the adverse remarks is coming. And the adverse remark was
That was endorsed by the other two officers. That was supported by the other two officers. So that should have been communicated to the petitioner also.
No, once the IO's remarks is communicated,
My lord.
then that is sufficient.
My lord, the remarks is not the complete ACR. Honorable Apex Court held that the entire ACR has to be communicated, not only the remarks.
But then you're saying that the reviewing officer and the accepting officer
Yes,
endorse the
remarks given by the IO.
remarks given by the IO.
Yes,
That way you've got the whole issue.
yes. But
Isn't
that is true. But my lord, but it was in part. It was communicated to the petition. Technically, it is not complete, my lord. Technically, it is not complete.
Okay. Okay, proceed.
My lord, the DPC was 22nd. No? The adverse entries and adverse ACRs were communicated to the petitioner, my lord,
For the period advert ACRs,
for the period 2005-6 average,
2000.
5-6
Oh,
average,
yes.
2006-7 average. My lord, prior to that, my lord, my ACR for the period 2004-5, it was part good and part very good. For the period 4-5.
Yes.
And after that also, my lord, 2007-8, my performance was very good. And 2008-9, this is the my lord, reckonable period, my lord, for consideration of the promotion.
Yes.
Uh,
2008-9
8-9 also good, my lord.
Good.
That is above the benchmark.
benchmark is
Good.
good.
Right.
So you agree by 2005-6?
5-6, 6-7.
6-7.
Right.
Okay.
DPC was held on my lord 22-6-2010.
Twenty-two.
6-2010,
Yes.
and it was declared on my lord 29-6-2010.
Yes.
The impugned ACRs were communicated, my lord, on 18 June 2010.
That is for which period?
Both the ACRs, my lord.
Okay.
Both the ACRs. And the petitioner received the same, my lord, on 8/7/2010.
Yes.
8/7/2010. So, my lord, the date of communication would amount to 8/7/2010. Because on that
So
day
this was after the DBC was held.
declared. Not
And
even held, it was
declared.
declared. DPC was declared.
Yes.
If your lordship goes by the decision of Obedience Court Justice there, which is the first judgment, my lord, wherein, my lord, it was held, the uncommunicated adverse ACRs are violation of Article 14. And therefore, my lord, the authorities were directed to consider the promotion of those officers who were not communicated the ACRs in time, to consider their promotion without considering those uncommunicated adverse ACRs. Following the judgment, my lord, that was referred to, my lord, the full bench in the apex court, my lord, in the case of, my lord, Sukhdev Singh, and the same judgment was held to be good by the full bench also, my lord. By following the judgment, later on, my lord, many judgments came, and your lordship also, my lord, held in the case of Dipson Nag, that non-communicated adverse ACRs cannot be considered for promotion while it was not communicated to the petitioner. And authority was directed to consider the promotion of that petitioner with retrospective effect. So, my lord, my batchmates were promoted immediately after, my lord, declaration of the DPC. I was at serial number 4. My juniors were promoted. Due to the impugned ACRs, my lord, I was not promoted. And well, as my friend has said, the first office memorandum came up in 2009, page 49. But it does not say that adverse ACRs were not required to be communicated. It said the other ACRs, good, very good, and outstanding, those should also be communicated after the case of Devdutt. By following Devdutt's case, this office memorandum was issued by the authority. Prior to that, also since 1985, there's a procedure prescribed for communication of the entire ACR, which are below the benchmark level, which are adverse. May I read the
Yes.
undersigned is directed to invite the attention of the ministries, departments to the existing provisions in regard to the preparation and maintenance of annual confidential report, which inter alia provide that only adverse remarks should be communicated to the officers reported upon for representation, if any. The Supreme Court held in their judgment dated 12/5/2008, that date may be, my lord, noted, 12/5/2008, in the case of Devdutt versus Union of India. Devdutt, my lord, he is also an officer from the same department, my lord, Grave. That the object of writing the confidential report and making entries is to give an opportunity to the public servant to improve the performance. The Second Administrative Reforms Commission in their 10th report has also recommended that performance appraisal system for all services be made more consultative and transparent on the baselines of the PAR of all India services. Keeping in view the above position, the matters regarding communication of entries in ACR in the case of civil services under Government of India has been further reviewed, and the undersigned is directed to convey the following decision of the government. Number one, the existing nomenclature of annual confidential report will be modified as annual performance assessment report. The full APAR, including the overall grade and assessment of integrity, shall be communicated to the concerned officer after the report is complete with the remarks of the reviewing officer and the accepting of authority, wherever such system is on back. Where government servant has only one supervisory level above him, as in the case of personal staff attached to the officers, such communication shall be made after the reporting officer has completed the performance assessment. This section is entrusted with the maintenance of APAR after its receipt shall disclose the same to the officer reported upon. The concerned officer shall be given the opportunity to make any representation against the entries and the final gradings given by the report within a period of 15 days from the date of receipt of the entries in the APAR. The representation shall be restricted to the special factual observation contained in the report leading to assessment of the officer in terms of attributes, work outputs, etc. While communicating the entries, it shall be made clear that in case no representation is received within the 15 days, it shall be deemed that he has no representation to make if the concerned APAR section does not receive any information from the concerned officer on or before 15 days from the date of disclosure. The APAR will be treated as final. The new system of communicating the entries in the APAR shall be made applicable prospectively only from the reporting period of 2008-2009, which is to be initiated after 1st of April 2009. The competent authority for considering adverse remarks under the existing instructions may consider the representation, if necessary, in consultation with the reporting and/or reviewing officer, and shall decide the matter objectively based on the material placed before him within a period of 30 days from the date of receipt of the representation. The competent authority, after due consideration, may reject the representation or may accept and modify the APAR accordingly. The decision of the competent authority and the final grading shall be communicated to the officer reported upon within a period of 15 days of receipt of the decision of the competent authority by the concerned APAR section. This is, my lord, regarding, my lord, communication of all the ACRs. It doesn't say that only the adverse ACRs be communicated. But prior to that, prior to the case of Devdutt, my lord, there is already a procedure prescribed for communication of all the adverse ACRs. Would very good and outstanding became communicable only after the case of my lord Devdutt. And by following Devdutt, this notification has been issued by the authority, DOPT. And the rejection, if you lordship peruses the rejection order of my representation, so she will find only on the basis of the comments of the reporting officers, my representation was rejected. My stand was not considered. But the guideline at page 52 says if required, comments of the reporting officers may be called for.
Yes.
The authority deciding the representation shall have to consider the stand of the officer who is filing the representation. If required, they can call for the remarks, comments of the reporting officers also. But the comments of the reporting officer are not binding. They have to apply their independent mind while deciding the representation on a quasi-judicial manner. That is the guideline of the DOPT. But in my case, the representations were rejected only on the basis of the comments given by the reporting officers. My contention were not considered. My lord. As on the last occasion, as a lordship draw the attention of lordships, page 38, which notification my friend has produced today, page 38, timely completion of annual performance assessment report. This particular notification of 23rd September 1985, it says Annex 3, page 47.
Yes.
Page 47. Clause 6, my lord. July 31st is the time prescribed for the reporting officer. Then if there is no accepting officer, then the ACR should be communicated within 1st of September. Means within a period of 1 month. And if there is an accepting officer, then 31st August is the reporting period. And it should be communicated to the officer within a period of 15 days, 15 September. This was prescribed way back in the year 1985. They cannot say.
What does that communication say? 23rd September 1985, which was produced today. You've got the copy? Okay, it prescribes the
Time schedule. my lord.
time schedule,
schedule
how the
yes.
ACS are to be
Mm.
written.
To be, my lord, endorsed and communicated. So far as communication of entries is concerned, my lord, it was communicated. And
Anyhow, that will hear you.
that issue has also been decided by the division bench of this honorable court, my lord, in the case of Samir Kumar, Kiras Kumar, and Shivalak Singh.
Then come.
That those cases were, my lord, challenged before the Supreme Court also, my lord, by the authority. Those SLPs were also dismissed. Now they had to communicate the, my lord, ACRs to the petitioner within a period of 1 month from the reporting period, but they did not do so. They have communicated the ACRs, my lord, after a gap of, my lord, around 5 years. That communication cannot be said to be communication.
Yes.
Lordship, kindly peruse the seniority list, which is at page 91. Page 91 of the petition, Annexure 12, my lord.
Yes.
I am placed at, my lord, serial number 4, Pankaj Dixit,
Pankaj Dixit.
my lord. And in terms of the DPC declared on 29/6/2010,
Where's the DBC minus?
DPC minus my friend will have, my lord.
Okay, okay. You will- Where the declaration of the DPC?
My lord, the posting order loss will find at page 94.
Yes.
Here, my lord, loss will find only one person is senior to me. That is Abhinash Tripathi at serial number A. The other persons are all my juniors.
Yes.
So, my lord, if my promotion is considered by following the next below rule, without considering the, my lord, the uncommunicated advice ACRs, then I will be, my lord, placed before them, the juniors, my lord. Now, my lord, I have been promoted after a gap of 4 years, my lord. I have been promoted without considering those
You
ACRs
promoted to?
to the post of executive engineer, my lord.
When were you promoted?
Mhm.
Where's the order?
Promotion order loss will find at page 139, my lord. In the year 2015, after 5 years, my lord. Serial number 1. A. Serial number A. I'm sorry. Pankaj Dixit. But this promotion has been made.
This is order dated?
This is order dated, my lord. 26 June, my lord, 2015. 26 June, and on page 174, also you'll find, 140, also you'll find the date down below. Left side, my lord, 26 June, 15.
Yes.
After a gap of 5 years, almost. So, my lord, I approached this honorable court at Itanagar bench by filing WPC 519 2018. Also, you'll find the order at page 141. This honorable court, without entering into the merit of the case, directed the competent authority to re-examine my representations.
Page 141.
141, it starts from 141 and concluding paragraph also you'll find at page 148. There is a clear direction. Therefore, upon due consideration of the case, it is in its entirety, I am of the considered view that the respondent authority concerned should revisit the grievances projected by the petitioner through his representation dated 27/2010 and 33/2011 in particular. 33/2011 in particular. Such examination should be initiated and completed as expeditiously as possible, preferably within a period outer limit of 6 weeks from the date of receipt of certified copy of this order. Needless to mention herein that my lord. So thereafter, my lord, what they have done, impugn order at page 149, they have rejected my case only considering the representation dated 27/2010. My representation dated 33/2011 was not considered at all.
How do you know that?
It is not stated that. They have, it is not stated that 33 is not.
My lord,
How do you know that?
when there is a direction from this honorable court, the rejection should have been, my lord, speaking. Rejection should have been skipped, my lord, speaking, and reason should have been assigned. No reason has been assigned. If you lordship see, the paragraph 2, Pankaj Dixit, so-and-so is hereby informed that issue raised by him in the court, case number so-and-so, dated so-and-so, have been given due consideration by the competent authority, who has concluded, directed that no new points have been noticed on the issue and case is devoid of any merit. Hence, the same is rejected.
Yes.
There is no reason assigned by the authority while rejecting my representations. Though there is a direction of the honorable court to revisit the earlier decision. So, my lord, this is the factual position of the case. And now I will rely on the decisions this honorable court as well as the honorable apex court, wherein, my lord, this issue has been dealt with. my lord, in paragraph 15 and
This book,
16 of my petition, I have
paragraph,
paragraph 15 and 16 of my petition. I have, my lord,
yes.
retained the various loopholes while preparing my ACRs by the reporting officers, my lord. Paragraph 15 and 16. In the first ACR, that is 14/5/2005 to 9/1/2006, I did not even work under the accepting officer for a period of mandatory 90 days. He cannot make any report if I do not work for 90 days under him. That is one defect, my lord.
Is it necessary that you have to work for 90 days?
Yes, ma'am.
With the accepting authority?
With all the authorities, under the all the authorities, my lord, reporting officers, all the reporting officers, my lord, 3 officers, my lord. I have to work for 90 days. And that is why, my lord, the ACR starts from, my lord, 1st of April of every year, and it concludes on, my lord, 31st of March of the next year. But in some ACRs, which will find some periods are missing, because during that period, I was not working under the particular officers. That is why they could not report for that period, my lord. Here also, my lord, also will find ACR should have been from, my lord, 1/5/2005, 1/4/2005, and it should have been up to 31st March 2006. But it was from, it starts from, my lord, 14/5/2005 to 9/1/2006. So this period, my lord, within this period, I did not work for 90 days under the, my lord, accepting officers, AO. If you lordships turn to page 73, my lord, column 13 of the ACR impute. Here, lords will find serial number C, accepting officer. Under him, my lord, it is
Serial number?
C.
Page 73.
73, my lord.
Okay, yes.
Accepting officer. That is the period loss will find 2/9/2005 to 9/1/2006.
Yeah.
9/1/2006. But during that period, I was on leave for 40 days. So, my lord, I did not work under him for mandatory 90 days. the period of leave cannot be considered for, my lord, for the purpose of completing the reporting period. Self-appraisal also will find at page 72 is the self-appraisal of the petitioner. Then page 73, column 14, both the IO and RO has agreed with the self-appraisal. That means my achievement has been endorsed by them, but they have agreed with my achievements. Procedural court pilot. This is the self-appraisal at page 72, and my lord, serial number 14 at page 73. Both the reporting officers, my lord, IO and RO, they have agreed that I did those works. But my lord, against the column for my lord, gradings, page 77, serial number 22.
Yes.
The IO says he is well educated. He looks confused. He only looks at problems from his own point of view. Overall grading is average. Before giving an adverse remark, the officer who, my lord, initiates my SCR or reports my SCR or accepts my SCR, they have to give me performance enhancement counseling. If I am not performing below, they have to upgrade my performance by performance counseling. They did not do so. This is verbal only they gave because they have no record of performance enhancement counseling. So if the officer is not aware about his, my lord, drawbacks, how can he perform better? Whereas, my lord, in the preceding year, immediately the preceding year, he was graded very good. Abruptly, he was downgraded to average. That cannot be accepted.
Next.
So, my lord, in the other ACS also loss will find, I have mentioned in the other paragraph, my lord, that the ACS were not, my lord, recorded in terms of the DOPT guidelines. So those ACRs cannot stand. That's good enough. Dishonorable court. More so, even without entering into the merit, entering into the facts of the ACRs, lordship can dispose of the writ petition on the basis of the dates of communication of the ACRs, because it was communicated to the petitioner on 8/7/2010, whereas the posting order was issued on 29/6/2010. So without communicating the ACR, my case cannot be rejected. They have done so. Now I will take your lordships to the various decisions of the Honorable
I don't
Court.
think we can conclude today.
So we keep the matter as part of my lord, some other day, lordship. My lord.
But
No,
I have cited them. Also, Mr. H. Gupta, then it's CGC. For the response. 14 part. When do you want?
Any date, my lord. My lord, may I frame my lord few documents which I have produced today. My lord, since they were not part of the record, my lord, I want to bring it on record, my lord. I have given the copy already, my lord. Perhaps not required for, because the fact that the ACR is not communicated, my lord, 2007, we have communicated. And there is another,
You want to place this on record?
my lord. Because, my lord, there was an additional DPC also, which is not annexed by the petitioners. No, I have said.
So you want to file an additional affidavit?
Yes, my lord, just to bring these documents on record. I have already given the copies, my lord, there is nothing new.
Okay, heard, Mr. Then you cancel the order. I'm not keeping it parted then.
My lord, this will consume some more time.
Date may be fixed, my lord, I will just file it
More than 1
within a
hour
week.
in this case, my lord.
Okay, but I have cited.
Date may be fixed, I will file it within a week.
Mr. H. Gupta, then the CGC is allowed to file an additional affidavit. Let's see. Placing relevant documents on
No.
records, on record, stop. List the matter again on when do you want?
To be fixed, my lord. On 9th, my lord. On 9th or 7th, my lord.
Seventh is a holiday, I'm told.
7 election. On 7 is a holiday, my lord, election. 9th, my lord.
Ninth, as part of.
My lord. Oblige, my lord.
My lord, in respect of item number 25, 26, 27, these are serious matter. My lord, this person is going to retire next year, my lord. So can it be fixed on 16th of May, my?
May.
Yes, 16 May.
Okay, 25, 26, 27, on request made by Mr.
B. Boga for
B.
petition.
Barrow, Leonard Council.
I am for the respondent.
List the matter on
16 May.
Lordship, supply 31, your lordship. Hearing matter, it's a part heard matter, your lordship. Matter may be taken up on 38th, your lordship. 30th,
There are some difficulties.
lordship, the next hearing day, your lordship.
Second,
2nd of May.
on request made by MS,
F. N. Jaman,
you are appearing on behalf of?
MS R. Chaudhary.
Okay, on request made on behalf of Ms. R. Chowdhury, then counsel for petitioner, list on
2nd.
second.
May I please, Your Lordship? I'd like to mention, my lord, item number 14 and 24. If lordship may kindly taken up the matter on 2nd of this May, my lord.
Second, ninth,
14 and 24.
Nine, 14 and 2.
Deeply obliged.
May I please, Lordship? Lordship, yesterday I have filed a writ petition, Lordship. This has relation with item number 17, Lordship. So let this court matter come on 3rd of May, Lordship.
Item 17.
Item 17. Along with writ petition with filing number 4720.
No, filing number, let it come, then on that day you can mention it.
Lordship, then let the item number 17 be fixed on Friday, next Friday, Lordship. In the meantime, that matter will.
Request made by A.D. Chowdhury, then the counsel for the petitioner, list the matter on 3rd May.
3rd May.
Item
Alright.
number 21, second week of May or any date, my lord, after 7. A long matter.
Item 21.
Yes, my lord. Any date, my lord, after 2nd week of May or 3rd week. 6th date, maybe
13th.
13th.
Lordship,
13th, no. 16th.
16th.
Lordship, in item number 17, interim order to be continued.
With respect to item number 15, Your Lordship, may I pray for a date, Your Lordship? Only that much.
Okay, on request made by video. When do you want?
Any day next week, Your Lordship, Thursday.
Next week will be difficult. Many cases are listed. 9th.
Deeply obliged.